All right, members, welcome to the Judiciary Committee meeting. We are going to be looking at one bill, HB 1002. We'll start with a roll call vote.
Representative Crago.
Here.
Representative Larson.
Here.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Rodriguez Williams. Here. Representative Washut.
Here.
Representative Yin.
Here.
Representative Zwanitzer.
Here.
Chairman Olson.
Here.
Chairman, you have a quorum.
And even though I said a roll call vote, I guess we're done. Yeah. No, that was just a roll call.
Mr. Chairman, thank you. Mr. Chairman, members of the committee, I bring you House Bill 1002 and ask for your favorable consideration. House Bill 1002 is designed to push back against federal vaccination mandates. Through the bill's finding, it asserts the citizens of the states have certain rights under the U.S. Constitution, the Wyoming Constitution, and under Wyoming statute. The bill forbids a public entity from enforcing any federal COVID-19 vaccine mandate until all challenges have been exhausted in the federal court system. The bill gives the Attorney General, with consent of the governor, the authority to initiate or participate in litigation to resist COVID-19 vaccination mandates. Finally, the bill appropriates $1 million to the governor's office for the purpose of fighting federal COVID-19 vaccination mandates. And Mr. Chairman, I'll walk you through the bill. Mr. Chairman, if you go to page 1, section 1 is the findings. I'm not going to read all the findings. I'll just hit my highlights. You go on to page 3, Romanet 6, it says countless Wyoming citizens fear losing their livelihoods because they object to receiving a COVID-19 vaccination for reasons of personal conscience, religious conviction, or for medical reasons, including prior recovery from COVID-19. On to page 4, Romanet 7, the decision to receive a vaccination is a personal decision and should not be subject to government intrusion or dictate. On to Romanet 9, the 10th Amendment to the United States Constitution provides that the powers not delegated to the United States in the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Romanet 10, Article 1, Section 38 of the Wyoming Constitution provides that each competent adult has the right to make his or her own healthcare decisions. Romanet 11, through various legislative enactments, the legislature established its primacy over immunizations, and all immunization laws and regulations in Wyoming are based on laws that the legislature has enacted. Romanet 13, by imposing a COVID-19 vaccination mandate on the people and the businesses of Wyoming, the federal government's actions constitute an abridgment of both the United States and the Wyoming Constitution. And then, thank you, excuse me. Mr. Chairman, then on to the bottom of page 5 is section 2, and we go into 914-103 and we create new statute. And 914-103 is COVID-19 vaccine mandate prohibition penalties. And you'll see, starting in subsection A, definitions. You'll notice that Romanet 3 is public entity under 16.6.101A, Romanet 8, and I thought I had brought that with me. Let me see here. Just a second. Okay. So, Mr. Chairman, that definition is public entity means the state of Wyoming, any state office, board, council, commission, separate operating agency, department, institution, or other instrumentality or operating unit of the state, including the University of Wyoming, any political subdivision of the state, any county, city, town, school district, community college district, or any public corporation of the state. So it's a pretty broad, expansive definition of public entity. Mr. Chairman, get back to my place here. Mr. Chairman, we go on to subsection B. No public entity shall enforce any mandate or standard of the federal government, whether emergency, temporary, or permanent, that requires an employer to ensure or mandate that an employee shall receive a COVID-19 vaccination until the date that a federal regulation, rule, or standard takes legal effect that has the effect of requiring Wyoming employers to comply with the federal COVID-19 vaccination mandate and any challenge to the federal regulation, rule, or standard in the federal court system is exhausted. So until basically appeal through the court is exhausted. And then it says the governor shall certify to the Secretary of State any occurrence subject to this subsection. Subsection C, any person who knowingly and willfully violates subsection B of this section shall be guilty of a misdemeanor punishable by imprisonment not to exceed 6 months, a fine not to exceed $750 or both. Section 3, basically with the consent of the governor, gives the Attorney General office the authority to initiate or participate in litigation. Section 4 appropriates $1 million general fund to the governor's office for this legal effort. And Section 5 is the enactment immediately upon completion. And so, Mr. Chairman, I'd like to go back to, so what are the challenges? The bill, obviously, the reason I'm bringing the bill, I think the one thing we can kind of do here in this special session is push back on federal overreach, make a statement, give the governor some money to fight this battle. And I think it's probably less controversial. But what this bill also does, if you go to page 6 and you start on the very line 23, if they all line up with you, and you start with the word and any challenge. So what this basically says is that that a public entity can enforce a federal COVID vaccine rule until any challenge is exhausted in the court system. So while it sounds good, and if you want to go ahead with it, that's great. But we always wonder what are the unintended consequences. So I'm here to kind of reveal that, and I think there's people in the audience that can talk to that. So if you wait that long, and it was brought up to me, the idea of Medicaid, Medicare. So if you say that, whoever, you can't implement your basically your mandate, the COVID, you can't, we're going to tell an entity, you can't require vaccination. And the federal government says we are. There's a court case. It's not stayed. The court system's going forward. But if the rule is not stayed, then for example, if they didn't get people, they being an entity, let's say it's a hospital, let's say it's whoever, if it's a public hospital, it'd be captured in this. If they didn't follow the mandate, then very likely, we don't know yet because the rule's not out, but very likely their Medicare or Medicaid dollars could be at jeopardy. At the same time, the state is required to pay that, I believe. And so we could end up perhaps footing the whole bill. And then there's, let's say it's, and I've noticed there's people from the community colleges in the back, but let's pick anybody, any public entity that has a federal contract. Well, federal contracts are under this same thing. If we wait till a court, if it's not stayed, if the rule or regulation is not stayed, and we tell people that they can't vaccinate at the same time, that they can't force vaccinations at the same time, then they could be subject not to getting that money. Now that may be okay. It may not put the coffers of the state of Wyoming in jeopardy, but it could too. So I just think there's things there you have to think about. And then I'm not a big penalty guy. And so I think as you look at the penalty, you need to decide whether that's something that's worth pursuing or not. Even though we tried to do it in a manner that's knowingly and willfully. And so, Mr. Chairman, with that, I would stand for questions.
Committee, Representative Zwanitzer.
Thanks. Maybe one
Representative Yin.
question at a time. So Representative Summers, County Public Hospital, would I be correct that if they defy this, all they have to do is pay $750? Because a person would therefore be the entity under our laws, and it's a one-time fee. I mean, that's the only teeth in this bill to follow not following the federal guidance, if they enforce that, a public entity being a community college or, a city, tell me about the penalties. That doesn't seem like enough. And most municipalities, governments would say 750. Okay.
Majority Floor Leader.
Mr. Chairman, thank you. No, there's no big penalty in here for a reason.
But just to clarify that, Representative Summers, that subsection C on page 7, I think Representative Zwanzer is what you're referring to.
Mhm.
That is if the court assessed the fine, which obviously it couldn't jail the hospital, is what you're implying. Because it's the discretion of the court to impose the 6 months in jail for the hospital or whomever, right? Or the 750. So it's not a civil fine. I'm just being clear on the record. It's not a civil fine, it's a criminal penalty
Correct.
subject to the sentencing of the court. You said you had a series of questions?
Thank you, Mr. Chairman. Historically, we don't do a lot of legislative findings. We're one of the few states that is historically, we don't put findings in bills. This specifically isn't going anywhere in codified statute. So, and I guess the difficulty is, some word choices in here I might not agree with, but because it doesn't go into codified statute, it's not worth, I think, being nitpicky about, but maybe just some explanation on, is this any kind of boilerplate language? Did LSO come up with these findings, or how did we come up with the, 14 findings that you came up with? Are they from any type of federal action? Other states are doing this. Just some more information.
Majority Floor Leader Summers.
Mr. Chairman, thank you. And so, kind of tasked LSO to, take a look at, what might be violated by the federal mandate. And so what could we put in here that would kind of highlight what we feel might be violated? And then the co-sponsor on the other side had, I believe, the language on my Senate cohort, the language on page 5, line 14. That was his language. And he had let's say there was more, there was some, there was give and take, as when you have a co-sponsor, there's give and take on what's in the bill. And that's the piece that out of what he had that I agreed with. The rest were basically, we just asked LSO for a product.
Thanks. One more, Mr. Chairman. And so on page 6 in subsection B, it says no public entity shall enforce any mandate or standard of the federal government. So hypothetically, let's say the federal government, I'm going to be careful here. A city, a municipality, some public entity wanted to enforce a vaccine mandate. Under this language, as soon as the federal government does so, they would be criminalized. So right now, the federal government doesn't have a penalty out there. So if a private, like a public hospital or community college or a city did put that vaccination mandate into effect with their own representatives, that is okay up until this would take legal effect. And then after the fact, we'd be requiring them to take a punishment, because then they would have regulations that this bill would say are no longer allowed. I guess that's my worry. Do you read it that way? That before the rule goes into effect, right now a city, county hospital could do a mandate, which, as you know, there are some employers out there that are public quasi entities that are doing this. They could still do it under this bill up until the federal government allowed that standard to take legal effect. And do you see that as a problem?
Majority Floor Leader Summers.
Mr. Chairman, are they public entities? One. And because I might be mistaken on this, but I thought, and I don't know how far that, maybe it was just agencies that the governor had his executive order on. I think he did have an executive order at one time. So I don't know. That's a good question. Can't answer that one.
Representative Yin.
Thank you, Mr. Chairman. Mr. Majority Floor Leader, thanks. So a couple questions. So you outlined the concern with Medicaid, Medicare you outlined the concern with federal contracts. Was it brought to your attention that we might, that there's a possibility that we could lose OSHA primacy if Department of Workforce Services, for example, wasn't able or decided to follow our law instead of enforcing the OSHA regulation?
Representative Summers?
Mr. Chairman, no, I haven't been emailed or told that on this bill, but it's possible. I don't know.
Thank you, Mr. Chairman. One more question. So I'm trying to weigh how many people this would affect if every state agency, if every public entity decided to enforce this law. And, you know, I'm sure we'll hear from a couple of folks soon, but do you have a sense of how many people are enrolled under Medicaid and Medicare or work under a federal contract?
Mr. Chairman?
Yep, go ahead, Representative
Mr.
Summers.
Chairman, I have no idea.
I feel like we're going to get a relative answer to some of those questions
Great.
when we bring up the Department of Health.
Thank you, Mr. Chairman.
Committee? Go ahead, Representative Yin.
Thank you, Mr. Chairman. I just forgot about this. Mr. Majority Floor Leader, in section 3, you give, we give permission essentially to the Attorney General to initiate or participate in litigation. Is this anything different than what we have in the status quo right now?
Representative Summers?
Mr. Chairman, not really.
Okay. Thank you, Mr. Chairman.
Representative Summers, you said you're not a fan of penalties. So under the subsection C of section 2, given the choice between a civil penalty and a criminal penalty, which would be a better fit for this bill? The criminal penalty that you currently have?
Probably a civil penalty.
Or just a civil penalty? Okay. And would that, if we were to change that to a civil penalty, would we apply that to the any person standard or to the agency?
So, Mr. Chairman, I asked that when this bill was being drafted, and it was my understanding there was some challenge with it, maybe not with a civil penalty attaching it to an entity, but there was on the, attaching a criminal penalty to a public entity. So you guys probably know that law better than I do. So.
Because if there was a civil penalty or even under the criminal penalty, if a sentencing court assessed that penalty, where would it come from? Would it come? So let's say it was applied to the University of Wyoming, because universities under the public entity definition, correct? Then it would come from their budget, or we would backfill it from our general fund.
So, Mr. Chairman, good point, right? Are we putting a penalty out there on an entity that ultimately gets state money? Some of them do and some of them don't. Counties, towns get their own money, get state money. It's a combination probably with all of these entities.
Do you know, Representative Summers, if there's remaining ARPA dollars that we could assign as a backfill to that?
So, Mr. Chairman,
Or have we already allocated all those funds?
Mr. Chairman, to my knowledge, the governor's not even come out with his budget, which would include ARPA dollars, and certainly JAC has not acted on anything. So, and you'll see other bills in this special session that do try to appropriate, and there's some common language out there that LSO has to appropriate ARPA dollars. So,
Okay.
of course, Mr. Chairman.
Yeah.
Of course, you have to, ARPA dollars can only be used for certain things. So
Right.
you have to decide what it can be used for and whether it's an appropriate spend on ARPA dollars.
The any challenge portion of subsection B, and I think you spoke to this in your opening comments, and that's, if I understand that right, that's the portion of subsection B that could tie up Medicare and Medicaid dollars, because if, let's say it's a hospital district, for example, that chooses chooses to litigate the issue, or the issue, and the issue is being litigated, and that could last years, right? Then they may lose federal dollars on Medicaid and Medicare during that lawsuit. I think that's what you stated in the.
Mr. Chairman, that would be my concern. Ultimately, you're right. It's a small fine. So there's no, but also, do you want to put a public entity into the business of violating the law? You know, if you're just going to set up a law, you know, they're going to ignore because it's a $750 fine. It's probably not a very good law to begin with.
I just, and maybe the other lawyers could speak to this, but as I look at the language where court case, all remedies basically have to be exhausted in the court system. And as a lawyer, it's probably far and few between that a client comes into my office with a problem and there's not a possible remedy and not a possible route. I mean, it doesn't take much to come up with one more suit, one more claim, one more whatever. And so I wonder if that, what type of system did you envision exhausting all measures in the federal court before the second part can happen, where the governor has to come in and officially say, yep, everything's been done that could be done. I wonder if that's even possible to exhaust all efforts in a
So,
civil court.
Mr. Chairman, you know more about federal courts than me, but I assume this might be filed in a lot of federal courts, but if it's all the same, it's going to end up in one federal court, right? It's kind of my understanding. No, it can go to all different kinds of federal courts. So,
Yeah, especially if the entity depends on the connections. I could be in multiple courts, potentially even in Wyoming, but yeah, if I've got substantial connections in other jurisdictions, I may relitigate it. And I'm only have to change certain things in the lawsuit to entertain a new suit that's not barred under a previous suit, if it was ever even barred. How important is that provision to making your bill work? How important is it that it be exhausted?
Mr. Chairman, so I've never been one to have a bill out there that has tons of unintended consequences. So I think as you hear debate, if there's tons of unintended consequences, then it's your job as this committee to reel that in. Or you can just go, it's a small fine. Depends on what kind of statement you all want to make.
Representative Swanser?
Thanks. I'm just having difficulty. So when we talk about public entities, ultimately we're talking about taxpayer funded is a nice way to substitute public entity. Can you think of any other instance in our laws where we would have a taxpayer funded entity being assessed a civil or criminal fine, which they'd be paying with taxpayer dollars? And I just can't think of any. Maybe some of the other attorneys can. I'm not sure I know of any other place in our statutes where we'd have a civil or criminal fine on a taxpayer funded entity, because that would ultimately hurt ourselves or that district's taxpayers. Representative Craig is grabbing the mic next to me.
Representative Craigo?
Just to answer Representative Swanser's question, there are several. Public records laws impose civil and criminal penalties on our public agencies. Just that's one that pops into my head right off the bat.
Representative Oakley?
Thank you, Mr. Chair, Majority Floor Leader. I guess I just wanted to address a question that the chairman just brought up, saying that, it could be lengthy, of course, that we're talking about that this delays the mandate. But I guess my question is, isn't that the point? Isn't that what you're kind of trying to get at with this, which is saying that our state public entities won't enforce the mandate until it's fully and finally adjudicated that what the federal government is doing is legal? And until then, this law says no state mandate. I mean, isn't that exactly what you're trying to do?
Mr. Chairman.
Representative.
Mr. Chairman, thank you. It is, but then I didn't hear all of the unintended consequences until the bill came out, right? So I think what you have to ask yourself is, what are those consequences? You know, what ultimately would happen if this went into effect? And then, but yes, you're right. It was intended that way. We want to see all the process exhausted before we put the rule in place. But what's the trade-off? What's going to happen if we do that? And will we basically force public entities to violate a law we wrote to get the money or are they going to just comply, and then we, the state of Wyoming, eats the Medicare dollars? So, I just think I think you just have to think those things through.
Representative Provenza.
Thank you, Mr. Chairman. Representative Sommers, am I correct in understanding that the Attorney General's office typically is the defense for a state agency? So if an agency is sued or goes through litigation, the AG's office represents or helps in their litigation?
Mr. Chairman, it is. I think the reason to do this was just to make it very clear that we're authorizing the AG by as long as the governor approves. So I think it's just more or less, it's the same process, but it's just saying, hey, we've got your back, AG.
Yeah, thank you. So I guess what my concern is that if the AG's office has to defend a state agency in litigation, but then they are also supposed to initiate essentially prosecution, how do we account for that conflict of what the AG's role is? Are they defending or are they prosecuting?
Mr. Chairman.
Provenza, the prosecuting entity would not be the Attorney General's office. It would be someone like Representative Oakley, but at the federal level. Federal prosecutors, the way I see it, is that how you see it?
Well, be a state prosecutor, state law.
Oh, I'm back on the federal court portion. So it'd be a state prosecutor in a state county and we just passed. So I'm trying to remember, we just passed a law, Representative Summers, on jurisdiction that wouldn't place all jurisdiction on those cases here in Cheyenne. It could be wherever the injury occurs. So wherever that agency is located.
Mr. Chairman, I've never served on judiciary. I'm a farmer. So what I'm going to say, though, is I know that the court system has figured all these things out, and I'm sure that's not an impediment to this bill.
Representative Provenza.
Thank you, Mr. Chairman. So in follow up to that, the court system has figured all this out. What instance in state statute do we have where we are asking our state agencies to violate our United States Constitution supremacy clause?
Representative Summers.
Mr. Chairman, I can't answer that.
Representative Grego.
Mr. Chairman, Majority Floor Leader Summers, and this might be a question better directed to the Department of Health when we get there, but just throwing this out there. Do we know a timeline on, for example, and I'm talking about the clause at the bottom of page 6 that starts with, and any challenge to the federal regulation, rule, or standard in the federal court system is exhausted. Do you know a timeline on when, for example, we get notified from the feds that we're out of compliance? How long do we have to come back into compliance? If we were to leave this clause in the bill, would we have time to act upon that and buy ourselves time? Which is, I think, alluding back to what Representative Oakley said earlier, is really what we're trying to do here. I'm just curious, do you have any idea what that timeline is?
Majority
Chairman.
Floor Leader Summers.
Mr. Chairman, I don't.
It's in the
I don't.
rule. It's not written.
It's my guess.
Representative Oakley?
Thank you, Mr. Chair. Majority Floor Leader Summers. To go back to this discussion of the penalties, which I think is certainly problematic. I just can't wrap my head around quite what works here. But I did want to throw out, forgive, it's really not a question, I guess, or perhaps I could pose it as one, but looking at page 6, it says no entity shall requires an employer to ensure or mandate that an employee. And I guess what I'm getting at there is that singular. So I think possibly what you could be here addressing Representative Zwanitzer's issues of only a $750 fine. I would argue that this would say an employee, so it could be 750 times X amount of employees. Again, that's just a thought. I mean, is that what you would understand, I guess, Representative Summers?
Mr. Chairman? Mr. Chairman, I don't like the penalty piece. That was an agreement with my co-sponsor. So can't answer that question.
If we take away the penalty, Majority Floor Leader Summers, then what induces the agency to follow the statute? I mean, this is an interesting topic of agencies following statutes for the Judiciary Committee, because we just held a committee meeting where an agency testified before us that for 2 decades, they have purposefully not followed one of our statutes. We're going to fix that statute, but there's no teeth in that statute. So there was nothing that automatically occurred over those 2 decades. So it's kind of I guess it's a little bit of a sensitive, interesting topic that the judiciary is wrestling with right now, is this concept of oversight from the legislative branch, where we are tasked with not only putting laws into the Green Book, as you know, but with going back and having oversight over the laws that we produce to make sure that the agencies that we are asking to do something, do it. If we take away, instead of modifying the teeth, if we get rid of the teeth, that criminal penalty, there's no civil penalty, there's no criminal penalty, what induces them to comply with our statute?
Mr. Chairman, and I'm a naive guy, but I try to follow the law. I would hope our agencies would try to follow the law. Ultimately, you can come back and hammer them if you don't like the way they've done it. And I would assume if you went back and looked, it'd be interesting in the instance that you provided. Did you go back and listen to the testimony when that bill was originally put into place? And maybe they debated penalties, and maybe they had a reason at the time why they didn't put in a penalty. And so all of that's part of the record for sure, and it would be now. So yeah, it's your choice.
Anything else for the Majority Floor Leader? Anything else for us?
Oh, Mr. Chairman, all good questions. I can't answer all of them, but I've never been able to answer all the questions of a good committee.
That's all right. We appreciate you. And I'm sure we've got folks who want to testify on this bill that will probably provide greater insight to some of the questions we've had. I'm going to go ahead and go straight to Department of Health, because you can certainly jump in with anything you're going to want to talk about, Stefan, but I know the primary question on why I asked you to come over in consultation with the Majority Floor Leader and some of the conversation we've had on that subsection B is that concept. Simply put, if we ask you to do something, your agency, and you say, okay, does that jeopardize Medicaid, Medicare dollars? what are the dollars that we're looking at? I think one of the questions was the number of people who are served under that. Stefan, go ahead.
Thank you, Mr. Chairman, members of the committee. My name is Stefan Johansson. I'm the interim director for the Wyoming Department of Health. Just by way of background, I think we're all talking about two things here, and I know you all know this, but just to reiterate, with the vaccine mandates that we all know are coming or impending from the federal government, kind of two tracks there. One on the large or employers with over 100 employees on the OSHA side, where we anticipate rules coming out there, and one on the Centers for Medicare and Medicaid Services, which we call CMS, that regulates any healthcare provider that treats Medicare or Medicaid clients and receives reimbursement from the federal government in the Medicare sense, and from the state and federal government on the Medicaid side, which is a joint program. I'll be talking about these impending CMS rules for the COVID-19 vaccine mandate that we anticipate is coming. We don't know, to Representative Zwanitzer or Chairman Olson's point, I can't remember who made it. We are awaiting those rules. So there's a lot of details with how it will be enforced, what the penalties will be, what the timelines will be that unfortunately I can't answer today. I can certainly give you my best guess, what I've heard from Baltimore and DC of how this might roll out, but there's just some limitations of what we know right now. What we anticipate, though, is that for certain types of Medicaid and Medicare providers, for example, hospitals, nursing homes, other types of congregate care providers, potentially those that serve the developmentally disabled could be included here, that there will likely be some sort of COVID-19 vaccine mandate. Again, don't know all of the rules yet, that will have to be abided by at some point in time for that provider to receive those federal funds either through Medicare or Medicaid. The issue of how that would be enforced is, I think, very important in the context of House Bill 1002 here with regards to public entities. Obviously, publicly owned hospitals or nursing homes would potentially be impacted by this bill. And as you've been discussing, would have a choice. Do we follow the state law if this were to pass, or do we follow a federal law or federal rule and regulation for a vaccine mandate when that comes out? In addition, the way that would likely be enforced from the federal government is really through the Department of Health, which would be a public entity as defined under this bill. The way that works, members of the committee, is essentially through the certification process, where we, as the Department of Health, in one of our programs called the Office of Healthcare Licensing and Survey, we have the duty on behalf of CMS in that office to certify Medicaid and Medicare providers, including hospitals, nursing homes, and other types of providers. What I anticipate is that this COVID-19 vaccine mandate from CMS will be considered a condition of participation in both of those programs, Medicare and Medicaid. Typically enforced, again, by our Office of Healthcare Licensing and Survey. We enforce and do surveys on healthcare facilities to assess those conditions of participation and if they are met. There are a lot of different conditions of participation in these programs, and we, on behalf of CMS, review, survey, and enforce those. That's how I anticipate this will be enforced through the federal government. And again, as a public entity defined here, our Office of Healthcare Licensing and Survey would have a choice. Do we abide by this state statute if this were to pass and do that certification or decertification work, or do we not? If we didn't do that certification or decertification work to see, on behalf of CMS, if hospitals were complying with the vaccine mandate, if nursing homes were complying with the vaccine mandate, if we chose not to do that, I assume the federal government through CMS would do it on their own and potentially defund our office in its certification work. What I want to clarify that I don't believe would happen or be triggered automatically, as has been discussed or stated before, if certain facilities do not comply with a vaccine mandate from CMS, it does not automatically trigger the state Medicaid program to pay state general funds for that lack of federal funds, if that makes sense. So the financial burden, as I understand it today, and bear with me because rules could come out tomorrow that change this, But as we understand it right now, the state Medicaid program, both in terms of that vaccine mandate and this bill prohibiting vaccine mandates, would not be the entity at risk. The real entities at risk in this dynamic are the facilities themselves. And also our licensing and survey office, which is relatively speaking a small component of the Department of Health that surveys state life safety code, construction standards, things of that nature, and also puts their CMS hat on from time to time to enforce federal conditions of participation in Medicare and Medicaid. That's the real rub here, members of the committee, is as Majority Floor Leader was speaking of earlier, that facilities really face a challenge of could they continue to receive Medicare and Medicaid funds if they chose to follow this state statute, if it were to pass, even if we weren't doing that certification work to say to the feds, nursing home A and nursing home B are not complying with the vaccine mandate, we decertify them as a provider. The federal government would likely do that on our behalf. So I think that the issue is most importantly with the unintended consequences here of various facilities that may choose to follow the state statute being unable to receive their Medicare or Medicaid reimbursements. Mr. Chairman, and on the Medicaid side, which the Department of Health oversees, we really don't have involvement on Medicare, but I wanted to address a few questions earlier and just in general make it known that providers across the state of Wyoming, including hospitals, nursing homes, and other types of providers, often depend very, very heavily on Medicare reimbursements and Medicaid reimbursements. Sometimes the majority of the business are subsumed within those two categories of reimbursement. Happy to provide the committee a breakdown of the number of facilities that we anticipate would be subject to a mandate like this. I don't have those numbers in front of me, and certainly the number of people served. Just for your reference, Wyoming Medicaid serves approximately 65 to 70,000 individuals on a yearly basis in some form or fashion. So that would be essentially the number of people that could in some way be impacted. But it's important to note that not all of those members receive services in a year from a hospital or a nursing home. So it really is quite variable with what the impacts could be. But just to reiterate it in conclusion, I think this bill and the dynamic with what we anticipate to be federal rules coming on the CMS vaccine mandate would primarily be the impacts would be directed primarily at our facilities. And in this bill, especially the publicly owned facilities or public entities, and then our enforcement as a public entity to do that certification or decertification work. Mr. Chairman, I know that was a lot. Members of the committee, happy to stand for any additional questions.
Vice Chairman Washington, Representative Zwanzer.
Thank you, Mr. Chairman. Director, can you tell the committee, I've got two questions here. How much does Wyoming receive in federal funding for Medicare, Medicaid total?
Mr. Chairman, Representative Washit, it varies from year to year, but in ballpark figures, it's in the hundreds of millions of dollars on a yearly basis from the federal government. Our biennial budget in the Medicaid program writ large for all of our Medicaid programs and services is about 1.3, 1.4 billion on a 2-year budget cycle. Typically, our federal match and state match is a 50-50 split on services.
Thank you, Mr. Chairman. And if Wyoming were to make the policy decision to make those providers whole during this period of non-compliance where they were not deemed eligible to receive federal funding, do you believe that once this is over and they become compliant, that they'd be quickly reinstated for federal funding, or could they just be left hanging and this become a state responsibility into perpetuity?
Mr. Chairman, Representative Washit, that's an excellent question that I can't answer. We don't know the details of that federal rule yet, whether retroactive billing when a provider came into compliance would be allowable, how long that would be allowable. I think if the state made a policy decision to make providers whole who complied with a state law like this, as opposed to a federal mandate, the real question would be how long would that period be? And to Chairman Olson's Olson's point earlier, those legal timelines are difficult for me to estimate for this committee or others of how long a challenge would take. But the costs of on the Medicaid side are the numbers I gave you. On the Medicare side, that grows even larger for some types of facilities like hospitals and nursing homes. So it would be a significant investment. And then that timeline would be certainly in question. Third, would the federal government, if facilities ultimately came into compliance after the courts decided the issue, would they be allowed to retroactively bill? It's difficult to say at this time.
Stefan, I'm thinking about the question of the state backfilling that, or rather taking on that expense of Medicaid in that event. And I'm remembering back to the last session when we had a bill on Medicaid expansion. Maybe you'll recall, when we were paying for our match, do you recall if we were paying from ARPA dollars? Or were we paying from our own general fund?
Mr. Chairman, in terms of Medicaid expansion, Wyoming has not elected to move forward with that. We do have various match rates depending on the service. For example, technology investments are matched generally at 90% or 75% for maintenance. Most services for Medicaid clients in Wyoming are a 50-50 split between the state and the federal government.
Right, but I'm just recalling back to the draft bill we had. I feel like we found a way to cover our match through ARPA dollars.
Mr. Chairman, you're right. Right now, through the ARPA legislation, if states elect to expand Medicaid per the Affordable Care Act, there is an incentive through ARPA to increase the state's match. Until Wyoming elects to do that, we obviously don't receive that.
Okay, so we were able to do that because there's a specific provision that lets us use ARPA dollars for that match. Would there be, just to your knowledge, any way to use ARPA dollars to subsidize the loss for failure to comply with the federal mandate?
Mr. Chairman, that's a really good question. The details of digging into the Treasury guidance, I think would be, and having those conversations would be necessary if that was a policy preference of the legislature. You get into issues of matching federal funds with federal funds and various maintenance of effort problems. I'm not saying it would be impossible. On the Medicaid side, it would be, again, a significant investment of state dollars to provide what was federal match. But I want to be clear to the committee, if I may, Mr. Chairman, that
Sure.
Through, again, there's no trigger if this were to go forward that the Medicaid program would, in essence, be on the hook for those dollars that are no longer coming in and reimbursing providers. It would be a policy decision on the side of the state. Whether that goes through the Medicaid program or not, we would have to look into those details as a state general fund only kind of payment. But essentially, Medicaid's role in this is pretty minimal. When CMS, whether it's through us or not, would decertify a provider for not complying with the vaccine mandate, essentially they're no longer an enrolled provider with Medicaid, and we just would not have any ability to pay them anything. Now, backfilling that with general funds, we could potentially do that through the Medicaid system. We have the technology and the claims processing to do it, but it would be something that standing up in short order would be a challenge, something that we could certainly talk through, but it would be a different way of conducting business largely in Medicaid.
Right, there's a lot that has to happen there.
That's right.
I
Mr.
think to your
Chairman.
point is very critical here. There's no automatic trigger. All the politics of DC would have to come into play, right? And at the end of the day, whether basically DC chooses to decertify a facility in Wyoming is a pretty big decision to decide that community doesn't have services anymore. That's both a policy decision and frankly a political decision that I don't know if that's an automatic given, depending on the population that loses services. And this big question.
Mr. Chairman, if I may, in addition to that, again, the application or the implementation of the financial penalties remains to be seen what that looks like. For example, in nursing homes and certain types of facilities, it could be levied as a civil monetary penalty from CMS or the federal government. Maybe not the full amount of funding, but maybe. In hospitals, is a decertified provider, no longer able to bill for Medicare services? Well, that's a significant part of the balance sheet that wouldn't be coming in. And I know I'm frustrating the committee, but we just don't know all of those details until we see the rules come out.
Right. Representative Swanser, you had a question before I jumped in.
A couple. So just generally, any further guidance from the federal government, anything you've heard about when rules might be published? And maybe some follow-up if they are even under emergency rules. I'm assuming we get 30 days like every other, at minimum. I can't imagine they'd be violating too many current federal laws, but overall, like 1.2 billion a biennium, if the feds took it, and eliminated that funding, Wyoming would be on the hook to make up for potentially, or everyone who gets CMS money quits taking Medicaid and Medicare patients, either of which would be, devastating beyond, I think, anything we can imagine. But that sounds right. We're risking 1.2 billion a biennium potentially by making our largest providers, hospitals primarily, decide whether or not to comply with the federal government or our state law.
Mr. Chairman, Representative Swanitzer, to clarify, our full budget for Medicaid on a 2-year cycle is about $1.4 billion out of the Department of Health. So on an annual basis, if you take that as roughly a 50-50 match, 2 years, that would be $700 million state funds, 700 federal funds. It doesn't break out as easy, but for the sake of discussion. So on an annual basis, we're talking about $250 million in many cases of federal funds. But I want to be clear, not all of those would be at risk. It's still very large. Hospitals, nursing homes, some of these providers we're talking about are really the largest expenditure areas in Medicaid. Again, details pending from the rule. I think the funds that are being risked on the facility side are the largest share of this potential unintended consequence of providers not being able to receive those reimbursements and maybe have to make the decision or be forced to make the decision to not serve those patients.
And what is, I know you don't have a crystal ball, but you're obviously tracking this much in terms of the track 2, as I'll put it, the CMS rules. You're tracking them heavily, obviously. If these regulations were to come out, I feel like you'd have a pretty good idea if we thought they were coming out next week. They're probably 30, 60, 90 days away, right?
Mr. Chairman, again, don't have the crystal ball. We anticipated the rules or have been anticipating the rules for CMS to come out this month. Now that we're in the last week of October, I think that might not happen. So I've been telling folks for the past month, end of October, early November. I think we're now hopefully in the early November stage so that we can at least see the rules. I don't know what the public comment period, if any, that will be allowed. Typically on some items that CMS does in rulemaking process, it is a 30-day public comment period, sometimes 45, sometimes 60. I've heard, and I think folks in the audience here could probably testify to their conversations and their associations. I've heard both that there will not be a public comment period, and I've heard that there will be. Again, policy by press release is tough to deal with sometimes from the federal government, but that's where we've been since September.
So then I feel like, there's obviously 2 sides to this approach, and we've been debating it all day, but we could sit idle, wait for a regulation officially come out, public comment period passes, it goes into effect, then we're in session in February, and then we respond to it. Conversely, we could pass, House Bill 1002, Chief Executive signs it into law. Regulation comes out a month from now, comment period goes into effect. We're back in session in February where we can assess what that regulation's impact is on the law that we just passed and on our facilities. So, I guess my question would be, if we were to pass this bill into law and facilities were to decide, actually, yeah, okay, there's not an effective date. It's just it's going to go right in. Let's say it gets signed into law, goes right into effect. Facilities decide immediately to begin compliance with state law. Is it realistic that there would be an impact within the next couple of months before we're back in session?
Mr. Chairman, difficult question to answer, and I want to be conservative here and say that yes, there potentially could be a short-term impact depending on that timing. If we see the federal rules come out and there's a limited or short public comment period, and let's say for the sake of discussion, the rule goes into effect on December 1st, and this statute is also on the books, then public entities like hospital administrators of publicly owned hospitals, nursing home administrators of publicly owned nursing homes, myself as the head of the Department of Health with our licensing and survey arm would have that choice of, do you comply with the state law? Do I face a fine or imprisonment by doing our work that we normally do to certify or decertify providers based on many conditions of participation or not? And then we would make that decision as the Department of Health, likely because we like our state legislature better than our federal overlords, that we would comply with the state law, but CMS would likely come in on our behalf and do that certification and decertification work for Wyoming facilities with respect to the vaccine mandate. Again, those facilities subject to these that receive these Medicare and Medicaid dollars, I think in the short term, Mr. Chairman, could face more grave short-term consequences. I also don't want to be hyperbolic and oversell that, because I think there's also a chance that this rulemaking process could be lengthier. And potentially this committee and the legislature could have a chance to re-review the legislation, but that is a risk I think that you'd be undertaking there.
Sorry, you just prompted me into one more school of thought, and I probably learned this at some point in my legislative career, but on the reimbursement, when does the reimbursement take place? It's not monthly, is it?
Mr. Chairman, when providers submit claims to us in Wyoming Medicaid, I won't speak on the Medicare side. Again, we don't have involvement there. That's strictly a federal program, but a significant one for our providers. On the Medicaid side, we on average pay claims when we receive them within 1 to 3 days. So it's relatively fast. Different provider types bill at different frequencies. So, depending on their cost structure and their balance sheets, hospitals generally, submit claims more on monthly basis, whereas, waiver providers for the developmentally disabled, they're not as, significant in their daily cash flow. So they submit claims more often, and I think don't have as much of an ability to float, essentially, if I'm understanding kind of the intent of your question.
Actually, that is helpful. So it is almost in real time. The reality of whatever happens from November 1 to February 14th, those claims are the service is going to occur, the claim is going to be submitted, and potentially it would generally be reimbursed within that period of time.
Mr. Chairman, within variation, but yes, I think there's providers that would be subject to both the federal mandate and this law that I would fall in more of a short-term billing cycle, where if they were decertified as a Medicare and Medicaid provider, could face significant short-term financial challenges.
Okay, that's helpful. Representative Oakley, and then Representative Provenza, and then Representative Prego, and then Representative Yen.
I better get all my questions in. Thank you, Mr. Chairman. And I guess my question is just a couple questions about certification, decertification. What do you think they would be looking at for a timeline if they were looking at decertification? I mean, with this discussion of, Medicaid billing being done fairly quickly, but they wouldn't decertify that quickly, would they?
Mr. Chairman, Representative Oakley, I'll add to the layers of frustration that I'm putting on this committee. It depends. With conditions of participation, there's various ways that can work from CMS review and survey. Providers, if they consider it an immediate jeopardy, what we call an IJ tag for various types of facilities, funding can be withheld very quickly. Essentially, they can shut it off the next week. And a lot of facilities face that when you have serious life safety issues that need to be corrected, or at least they were alleged. Other types of conditions of participation, you're right. There are times where CMS will say on condition X, you have so many days to come into compliance or face a financial penalty or face decertification and loss of all of your funding. It really, really depends right now on what's written to the rules. And it also depends on the provider type with how any financial penalty or withholding of funds will be assessed. I really, truly wish I had a better answer for you, but until we see it, I struggle to give you my guess of how that will work.
Thank you, Mr. Chair. And so speaking of frustration, probably you're going to be frustrated with us asking questions that you keep saying, I can't answer that. But okay, and I know this is naive sounding, but do you think that there's any chance that it would make it more likely that they wouldn't decertify or take away funds in recognition of a difficult situation? Like, let's say we pass this, didn't do a penalty, for example, but so they are looking at competing laws. Is there any chance of them wanting these facilities to receive the needed funds? In essence, could this be helpful to them is my thought.
Mr. Chairman, Representative Oakley, again, I'll struggle to answer that in terms of the game of chicken between state law and federal law. That's tough. I will say, and it's clear that on the federal side within Medicare or Medicaid, I think the agencies that operate those programs want and have an interest in services being provided to those clients. So yes, there will be discussions, again, depending on the provider type, depending on the population, depending on the geographic region. We are required as a Medicaid program to provide access and guarantee certain levels of access for our Medicaid members. So if providers were decertified, we would have a lot of work to do in a rural frontier state like this to find provision of service for them so that we can guarantee access, whether that is on the hospital or nursing home side, looking out of state for providers. We would have to look at all of those potentialities if something like this were to pass and if the federal rules come out and are something similar to what we're talking about with that type of decertification. Again, timing and financial penalties and those timelines for those penalties will be crucial. And I wish I had those rules sitting in front of me so we could better plan. We just don't at this time.
Do you have a recollection of or knowledge of the last time a facility in the state of Wyoming was decertified?
Mr. Chairman, in terms of conditions of participation that lead to complete decertification, I'd have to double check that, especially in the provider types we're talking about the last time that happened. But it's more frequent for various tags to be assessed when our folks or when CMS does different surveys and facilities for conditions of participation. But often there's, to Representative Oakley's point, there's periods of time to correct those. I'd have to get back to you in the committee on the most recent provider that was completely decertified from Medicaid. Medicare, again, kind of out of our hands, but we could certainly look into that.
And I guess to Representative Oakley's point, then, if the real question would be not whether there was to my question, not whether there was a decertification, but whether there was ever a decertification that occurred without a right to cure period, right? I think none of us have, I get that none of us have the rules in front of us, but I think all of our guts tell us there would be a right to cure process, right? Unless there's a history where it shows us where the federal government has been firm and said, nope, you're done. I kind of have a hard time believing that would happen.
And Mr. Chairman, again, I think you're largely right. I hate to speculate with my gut with federal law and state law that has these types of consequences. But again, if the feds were to put this in, the immediate jeopardy category, then those timelines do shrink when it comes to either financial penalties or certification status. But again, broken record here, we need to see those rules.
Did you have any follow-up, Representative Oakley? You good, Representative Provenza?
Thank you, Mr. Chairman. And my question kind of goes along with this, but from the other perspective of, does our state statute have an ability to kind of pick up the slack, say if there is a decertification, do we allow in statute or in our procedures through the Department of Health to say, okay, now we're going to fund the uncompensated care? Or is that something that we would have to go back into statute and create an entity, basically create our own Medicaid in order to be able to do that?
Mr. Chairman, Representative Provenza, at the very least, my understanding is that would need to be done through the appropriations process. Whether a statute would need to be changed if it was truly a short-term measure. There have been, general funds that are allocated to our budget through budget footnotes or actions like that. But there isn't a mechanism right now where if the federal government cuts off a stream of funds in Medicaid, that automatically the state picks it up. So I think that would have to be worked through, again, through what we would be looking for, because we're selfish in the Department of Health, is the money. And then if it were longer term, we would certainly need, I think we would all agree, we would want some statutory structure that allows for that.
And do you know currently how many people we are serving on Medicaid and Medicare?
Mr. Chairman, Representative Provenza, on the Medicaid side, on an annual basis, again, it's around that 65 to 70,000 people per year. I would have to get back to you on the Medicare side. That information is publicly available for Wyoming residents on Medicare, but it's easy to think about it in really two buckets. Those who are over the age of 65, typically most folks enroll in Medicare at that point. And then there's other individuals with certain qualifying conditions, disabilities, that are able to be on the Medicare program earlier, but happy to get you those figures.
Representative Provenza, we could call our Medicaid system cowboy care. I don't know if that makes it more palatable.
That's fine, or cowgirl care?
Or cowgirl. Thank you. Representative Yen.
Thank you, Mr. Chairman. Maybe, I was kind of interested in what the process would look like, right? For if it happened to a public facility like a nursing home, where we had that public facility decertified. And, I think some of that answered, well, there's the possibility of a cure period. I think that helped. So I'll try a different tact. What do you have a feeling, or maybe like a range of the number of cases of people in public facilities that contracted COVID from an employee?
Mr. Chairman, Representative Yen, I don't have those figures in front of me. I do not believe we have them broken out by public or privately owned facility. Could certainly do some work, and analysis to look at COVID infection rates in our long-term care facilities, which are large consumers of Medicaid and Medicare funding, but I don't believe we have it broken out in that way.
Representative Craigo.
Thank you, Mr. Chairman. Representative Oakley actually asked my question, so I don't have anything else.
Representative Williams.
Thank you, Mr. Chairman. Mr. Johansson, just curious, are there any states where the providers work directly with CMS at the federal level for certification, where they don't have a Department of Health that oversees the certification process, to your knowledge?
Mr. Chairman, Representative Rodriguez Williams, to my knowledge, most states have a similar structure to Wyoming with a licensing and survey arm that typically do health and life safety surveys per state law. We have a lot of state statutes that for life safety code and facility construction, things of that nature. And then the other side of that office is kind of the working as CMS to do Medicare and Medicaid certifications and surveys. I think most models are similar.
Thank you, Mr. Chairman. I did think of a question based on the director's comments. So the certification process, we handle that CMS certification through the state. If, for instance, a facility has a bunch of nurses, workers that say, we're not getting vaccinated, we're quitting, we're leaving, does that also jeopardize our certification? for that particular facility?
Mr. Chairman, Representative Crago, it's a good question. I think it would be kind of an indirect effect there, if I understand the question correctly, that where if you have essentially a staffing exodus out of a facility, that you would now be subject to an additional, condition of participation or immediate jeopardy where you can't provide adequate care. I think that's a potential. We haven't, luckily, we have not seen that. We've been able to work in partnership around the state of Wyoming to try to do some staffing stabilization and provide resources there. That's not to say it's not bad out there. We're having some significant issues related to staffing, not necessarily because of COVID vaccines, but because of exhaustion, other markets, picking up staff, salary competition, et cetera. So I'm not sure if that answers your question. It really, again, will depend on the detail of these rules and facilities and their particular challenges. If they see staff leave, maybe that would trigger additional types of survey, but it's hard to say.
You should have used your lifeline. Mr. Bowley was shaking his head. He had a direct answer to that question, which I know we're going to get now. In retrospect, I should have brought you both up here at the same time. Some of these questions, we're really asking a lot of questions about the providers, right? Oh, sorry, go ahead.
Mr. Chairman, if I may, just in closing, before you hear additional testimony, and I'll probably be summoned up to committee too. I do, not to be overly facetious, but let the committee know, Medicaid is a voluntary program for the state. I know that that's being thrown around a lot. There is not a federal requirement to participate in Medicaid. It's a voluntary program that we joined, I believe, in the late 60s. So that is certainly not an option we would recommend if in this type of discussion. But it's worth mentioning that this is something the state has elected to provide services for these members. Over time, those services and eligibility have obviously changed. Additional populations have the state has elected to serve, whether it's folks in nursing homes, primary care, folks with developmental disabilities, community waiver services. We have, I think, together as a state turned Wyoming Medicaid into what it is. And I think not to be braggadocious, but we do a good job in that program. But it is worth mentioning that it is optional.
Representative Swanser.
Thanks, Mr. Chairman. Do you know of any state, county government that has withdrawn from the Medicaid program from the federal government and just said it's not worth it to our state or our governmental unit?
Mr. Chairman, Representative Swanitzer, no, the last state to join Medicaid after it was Medicaid and Medicare were passed in the mid 60s was Arizona, I believe, in 1983. And no state has withdrawn since.
So just to be clear then, when we're talking about this subsection C on the criminal penalty, possible civil fine, really doesn't involve the Department of Health at all. We're talking about the agencies that are going to be, whether in compliance or not, are basically hospital districts, minus your certification department.
Mr. Chairman, that's right. If we chose to continue business as usual in our Office of Healthcare Licensing and Survey, I think we would be subject to the penalty or, sending me to jail, which I could use a break. So we'll consider that. For doing that, if we were to decertify a provider for not complying with the federal vaccine mandate, then we would be subject to that. But again, I want to reiterate the real impact here in our estimation is at the facility level.
Sorry, I keep asking.
Representative Swanser, then
Thanks,
Representative Yin.
Mr. Chairman, doesn't the Department of Health, you oversee programs like public health? Just the number of employees you have employed for you that are on federal Medicaid or Medicare funds, are those in jeopardy? That you would lose positions, or you do have some components, I think outside of licensing and surveying, public health just kept coming to mind, where you could be including these type of vaccinations. Any worry there internal to the department? I know we're talking about the big hospitals, but the Department of Health itself has a significant amount of employees on federal Medicaid dollars.
Mr. Chairman, Representative Swanitzer, two things there. One is, like you mentioned, our Office of Healthcare Licensing and Survey, what the feds would call an SA or a survey agency. that would be, I think, directly impacted by this based on our decision to either do that work or to comply with the state law. And that involves surveyors. And it's really, I should clarify, it's a partnership with the federal government. They use our staff, our engineers, our surveyors, our nurses to do that work out in the field. But there's also Region 8 CMS, federal CMS that will often come out as well for various types of surveys. So that would certainly be impacted here. The other area that I failed to mention, because I've been saying it's the onus is on the facility side here. It's important to remind the committee we have Department of Health owned and operated facilities that also receive Medicaid and some Medicare dollars, including the state hospital. The Wyoming Life Resource Center is heavily federally funded as well for those clients. In Lander, and the Wyoming Retirement Center in Basin also it's a revenue neutral facility, doesn't cost the state any general fund, but that's also heavily Medicaid and Medicare subsidized. So we would be, those facilities that we operate would be in similar situation to the facilities that we're all talking about in our communities.
And then just to follow up on that from Representative Zwanzer's question, then for the facilities, those state facilities you mentioned that are funded by or have some funding of Medicaid dollars, and the employees in the Department of Health that are funded by Medicaid dollars, those are all funded under the existing budget authorizations through this budget, through this biennium. So there couldn't be an impact. That funding's already obligated, right?
Mr. Chairman, on the staffing side, I don't have as many concerns with our Medicaid program and the staff that we have, the 100 series, which are state and federal funds, with the exception of that survey agents, the licensing and survey that we have. Depending on the timing of when things come out and what the timelines are, there could be some funding implication for the staff that we have in licensing and survey if we chose not to follow the federal rules and do that survey and certification work for the COVID-19 vaccine mandates. But again, I really struggle to get into the details there because we just don't know.
Right, but even in that hypothetical, Stefan, do you receive funding from the federal government monthly for those employees? Or have you already received that funding for the budgets, for the budget?
Mr. Chairman, it varies. For example, I have federal match in part of my salary for the work since, half of our budget, more than half of our budget is Medicaid and a big part of our programming. So that I don't think that would be at risk in this scenario, but it really does vary. We have federal funds that also in our licensing and survey office for salaries there that I believe are drawn down on a regular basis and not preloaded to, if I understand your question, but I would have to double check the mechanics of that.
Yeah, what I'm trying to envision is at least this is what the way I thought it would play out, which was that we're under the current budget that we're operating under. Those federal dollars were already authorized for those positions. So they're already, I would assume we would put that, that transfer would have already taken place, I guess, would be my assumption. And then what we would be looking at is when we come back in February, we would be looking at, now we know those positions don't have those federal dollars that they had under the 2020, 2021 budget. That's how I would at least assume that it would be. It wouldn't be next month we would learn that the federal government had defunded XYZ positions in the Department of Health. It would be through the budget cycle. At least that's what I would think.
Mr. Chairman, I can follow up on this, but just in general, the federal spending authority that we have through our budget and how that gets appropriated, there's a difference between the spending authority we have and the feds allowing us to have that money on a regular basis. I'm not sure, again, I don't want to overstate. I'm not sure how much of an impact on the position side we have here. It would take a little bit of investigation.
Well, we don't want to cut your salary in half between now and February. So, well, some people might, but I don't want to, Stefan. All right. Representative Yin.
Thank you, Mr. Chairman. Director, I'm trying to remember my question offhand. For the public facilities, so I'm trying to follow what the chairman said. For the public facilities that the Department of Health owns, would there be a loss of revenue if we had to decertify those facilities essentially immediately?
Mr. Chairman, Representative Yen, if the facilities I mentioned that the Department of Health operates, including the Life Resource Center, the Retirement Center in Basin, if those were decertified and the rules specified at the federal level that funding were to stop, there would be a significant financial impact there, a significant loss of funds. For example, Representative, at the Life Resource Center in Lander, it's approximately 70% federally funded for all of the operations and services.
Would it, Mr. Chairman, follow up? Would it get to the point where without an additional appropriation in the budget session, would it be possible to get to the point without an additional appropriation in the budget session that the facility wouldn't be able to stay running? Like it wouldn't have enough of a baseload revenue to keep it running with their current level of appropriation, Mr. Chairman?
Mr. Chairman, Representative Yen, I'm going to decline to answer that. I think it does lead to a little too much hyperbole. If, I just don't know what that timing would look like. But again, hypothetically, if a condition of participation resulted in immediate decertification and loss of funding, we would have significant challenges at several of our facilities.
Mr. Chairman, second question. Director, so I did remember what my other question was, which is the certification by the state. What is the benefit of the state doing it? Because I assume the reason that we do it is because there is some benefit to us or our providers. Thank you, Mr. Chairman.
Mr. Chairman, Representative Yen, to put it really generally and simply, there's multiple types of survey work that needs to happen, whether it's on behalf of the feds or on behalf of the state per state laws, that create some natural efficiencies there. And also I would say, tacit knowledge of state of Wyoming people, nurses, engineers doing that work. There's benefits there. But like I said, it certainly is a partnership with this survey work, and not to go too far into the weeds here, that it's not, we have a program in the Department of Health that just does the bidding of the federal government. It really is, as many programs are in the Department of Health that rely on state and federal funds, a partnership between the two entities.
Other questions? All right. Thank you, Director. Good luck in appropriations. And thank you for coming on short notice. Eric?
Good evening, Chairman Olson and committee members. I'm Eric Boley, President of the Wyoming Hospital Association and also Leading Age Wyoming. I represent all of the hospitals in the state and about 2/3 of the nursing homes in the state. And obviously we have some concerns with this bill. I have the utmost respect for Majority Floor Leader Summers, but I do think there may be some unintended consequences and some real issues with this. And I think the 1,000-pound gorilla obviously is the penalties and some of the definitions that go here. I'll tell you, I don't think the magnitude or the reach, the authority that CMS really has been adequately communicated here. All of healthcare is tied to CMS. All of our rules are tied to CMS. And I think Director Johansson, which I never want to see me go to jail, he's doing a great job. He's fantastic. Although he probably does need a break after the last couple of years. He tried to describe that, but I think the reality here is that while the state does do the licensing and survey process, there is very strict federal oversight. And so when the survey team comes into one of our facilities, whether it's a nursing home or hospital, they submit their findings to the regional CMS office, which is in Denver, that oversees 8 states. And then it's overlooked. It's looked over, not overlooked. I wish it was overlooked. Looked over, and then they can either justify and approve the citations that the state comes up with, or they can override that. They also sometimes will send a federal surveyor with our state survey team to oversee and make sure they're doing it right. And there's a large percentage of those when, after we've gone through the state survey, a federal team will come in afterwards and do a second survey. And so the feds are very, very involved in what we're doing. I have copious notes here to address a lot of the different things that we talked about. I don't want to belabor the point. The one thing I will tell you, nursing homes in our state, 70% of their clientele are on Medicaid. And then a large percentage of those that don't have Medicaid have Medicare. So it's probably close to 85% of their payer mix in long-term care facilities. In hospitals, the combination of Medicare and Medicaid is somewhere between 50 to 60% of their payer mix. And that also includes TRICARE, which is another fit in hospitals. As we look at this bill, I believe, based on some quick math, 15 of our hospitals, our critical access hospitals, would be subject to this. 4 of our larger hospitals that are memorial hospitals would be subject to this. 20, I believe, close to 20 of our nursing homes would be public entities and would be subject to this. I also want you to realize that not only is CMS one of the issues we have to face, but OSHA, the new OSHA requirements, we also have to face because most of them have over 100 employees. So we're caught between 2 different competing rules. With that said, and understanding our payer mix, if we had to decide between a $750 fine or not getting paid and not being able to admit patients and going through that whole process, we're going to pay the $750. The concern I have is that in section C, it says any person. So is that going to hold the CEO or the board chair or the board members that make the decision to implement a mandate liable? And the fact of them going to jail for any length of time, trying to keep their facility open and serve the public, I really have some serious issues with that. And I can't express that strongly enough. I don't think it matters whether it's criminal or civil. Both of them are problematic for our folks. The other thing is that CMS has the ability to stop admissions almost immediately. And there have not been decertifications to my knowledge, but there have been situations, especially in long-term care, which our hospitals are normally surveyed every 3 years, especially for our critical access hospitals. They go through an initial survey process to certify them as a critical access hospital. And then every 3 years, they have to have a follow-up one. Our other facilities go through a 3 to 5 year survey process, but they also have Joint Commission that comes in and other regulatory agencies that would more than likely report back to the feds because it's just how it works. But our nursing homes are surveyed every year, and CMS has the ability to extract their pound of flesh almost immediately. They can, once the survey results go from our state back to the feds and they've been determined to be appropriate, we receive letters almost immediately. And if a nursing home is in a condition where they've got some serious problems, CMS immediately stops their ability to admit any more patients and stops all reimbursement. We have a period of time to get our plan of correction put back together and get back in compliance. A lot of times they will do some retro payment, but the lost revenue from even admitting those patients is difficult, but their reach is long and strong. The other thing that kind of goes along with, so the other thing is they can also impose civil monetary penalties. And what they do there, and they do it all the time to nursing homes, is you either have to pay or they stop paying you until you've made up that civil monetary penalty. And it goes into a pool of money that the state kind of oversees. A lot of it goes back to the feds, but a portion of it can be used for improvements in facilities. Not sure they would use that remedy in this particular case. What Director Johansson did tell you is we're not exactly sure when the rules are going to come out, but we kind of have a glimpse as to what it's going to look like, and we feel like it's going to be onerous. Our national association, American Hospital Association, I was on a call with them late last week. We understand the OSHA rules have been promulgated, but they haven't been published yet. We also understand CMS is close to having that done. What they're doing right now, and this is how federal government works, they're allowing certain people to come in and provide comments on what has been said, but they're not allowed to even see what the proposed rules are. And then they'll take those comments and they may or may not work them into the rules. And then we hope that at some point, well, actually it'd be great if they never do it, but we hope at some point there will be rules that will be promulgated. I'm hearing the same as Director Johansson. There's a really strong chance, because this is connected to conditions of participation, there will be no public comment. I'm also hearing that they may follow the normal, which is 45 to 60 days of public comment, but we don't know. And I think that's where we kind of got the cart ahead of the horse right here. Is it would be nice to know what we're dealing with before we start passing legislation to combat something we don't even understand. Let's see. The one thing that I also say is every state's the same. CMS tries to be uniform in the way that they implement and how they oversee survey. They spend a lot of time training the state surveyors and working with the director of that department, and they try to have uniformity. We have seen some inconsistencies based on regions, but in our region, there's uniformity. The other thing that I would also mention to you, I heard it talked about, I think it's state primacy law, as we were talking about OSHA. We were on a call with Wyoming Business Alliance yesterday, and we're in lockstep with them. But right now we have state primacy laws, but other states that have opposed the federal government have had those stripped. And it's pretty important for us to be able to have our state OSHA operate independent of the federal government. But again, they have the hammer. And so if we do something that they're not happy with, they could strip that, and then it would all be federal. So I think it's one of the considerations that this committee needs to take into account. With that, I'll answer any question. I think you kind of know where we stand right now.
Yeah, and I think so, Mr. Boley, I would start with, because I just want to drill down to the actual, take away all the different, at the end of the day, there's a lot of what ifs that we're talking about, but the what ifs aren't one-sided, right? You're here telling us that there's a what if on the rules. We don't know what the rules are going to be, so it's hard to enact legislation, but at the same time, you're saying, what if with 70% and 50 to 60% of hospitals, 70% of nursing homes, what if they choose to follow our mandate? They may lose their Medicaid dollars. I mean, that is a huge what if from my perspective. Do you really believe that the federal government would strip 70% of all nursing homes in the state of Wyoming all at once for non-compliance and shut them all down? Do you really think that CMS would do that? I get that their reach is big, but if the purpose of the mandate is for the health and safety of the citizens of the state of Wyoming, why would the federal government shut down 70% of nursing homes and jeopardize the health of all those patients immediately for non-compliance with the mandate? To me, that's a bigger what if. I just don't think I'm not a gambling man, but if I was, I would say the federal government has the bigger gamble than this committee here today to shut down 70% of facilities.
Yeah, Mr. Chairman, I don't disagree with you. I do think that it's a scary proposition. I'm not willing to risk it either. And I do think that it'd be a huge disservice. I mean, one of the thoughts that I've had, and I've had this conversation with my members, is what if this happens? What if we lose a hospital? What if we lose a nursing home? And there are certain things that have to take place let's talk about a nursing home. If we lose a nursing home and they're shut down, we've got to be able to discharge those patients to a safe environment. Scary part is nursing homes may not be able to take them. So where are they going to end up? Maybe in the emergency rooms and hospitals that are already full with COVID patients. We're not able to transfer out of state. So I agree that the federal government could potentially create worse chaos than we already have. And I'll also tell you, I'm not for the mandate. I'm really mad at the Biden administration. I was really mad when they did the nursing home one standalone. And I thought that it would at least be fair if they did it across the spectrum, but it's the wrong way to go. And so I don't have any problem with us pushing back against that. What I don't want to do is I don't want to jeopardize, and I don't want to treat our hospitals and nursing homes poorly because they're stuck between a rock and a hard place. And that's where the concern is with a lot of the legislation that I saw come up for this session. So there's no problem with us pushing back. We're in a position where we can't win.
I think you guessed I think you guessed at this, and I guess it would probably still be a guess, but you said if your members, the facilities in Wyoming were faced with the choice of a $750 fine or whatever, or losing the dollars that reimburses their services, they're going to choose the fine. I mean, we can't know that for certainty, but it's a basic economic calculation. Give up $750 or give up, I don't know, right?
Yeah.
Millions.
Mr. Chairman, you're right. I mean, I'm not sure they want to go to jail for it, but
Yeah.
which is also in there, but yeah, for 6 months. Some of them
It's
might
true.
want a 6 month time off after dealing with COVID for the last 2 years too.
Would a civil penalty be more palatable then? Because there
I
wouldn't.
mean,
be
if
that
you
jail.
want to, if, Mr. Chairman, if we're going to do something, I guess that's fine. I mean, to me, you kind of already know the outcome.
Yeah.
So I guess if we want to generate a little bit of revenue, that'd be all right.
Representative Oakley.
Thank you, Mr. Chair, Mr. Boley. It's along the same lines, but okay, let's say we don't have a penalty. Do you think there's value possibly in creating a law like this that could act as a shield for facilities that do want to comply? They want to have something that says they don't have to do the mandate in state law. I mean, so I mean, it takes a lot of teeth away. We're talking about a much smaller, but do you think there could be value created in Wyoming taking a stand, having a law like this that says no mandate? And like I say, in this idea, my thought is no penalty.
Mr. Chairman, Representative Oakley, I mean, I think we're behind telling the federal government to get out of the way. We want less government involved because we're already regulated to the nth degree. So I don't think there to be any problem with that at all, as long as there's no penalty. And just to let everyone know, I'm not aware of any hospitals other than the system that has every right, because they're private, to do a vaccine mandate. I'm not aware of any nursing homes or hospitals that are considering a mandate. I know some of them are looking at changing their policies over vaccines and providing reasonable accommodations. So from a state perspective, I'm not seeing anybody that's really chomping at the bit to mandate it, but we do believe strongly that vaccines are the way for us to get out of the situation that we're in. But I don't think you'd have any pushback from it. I just don't know what good it's going to do.
You said at the end, what I was thinking with Representative Oakley's question is, I guess more specifically though, are there any facilities or providers in the state of Wyoming that you represent that have said we will not impose a mandate?
Mr. Chairman, there aren't any there are some that hope they can say that, but with the 1,000-pound gorilla hanging over them, beating its chest, that right now they're preparing for what's going to come. What that is, we don't know, but we've heard rumors. So they've got us over a barrel kind of.
So to Representative Oakley's point, does this bill then provide cover? Because it goes back to the initial conversation we had with Majority Floor Leader Summers about exhausting all court efforts. Obviously, a chief executive is engaging his branch of government in exhausting those court efforts. This bill really does call for more of that. It funds it. One, adds an additional appropriation of $1 million to the governor for those legal actions, and essentially says that's what we have to push forward, is we have to exhaust all efforts in the court system before we worry about the state mandate. So, I mean, does that not provide more cover for those
Mr.
agencies
Chairman,
that maybe don't want a mandate?
I think that's great. We'd like to see every opportunity exhausted, and it's going to be a long process. And that's the problem, is that our reimbursement is at jeopardy. Could be immediately. Like we don't know, but we don't have time to wait. I mean, if you're talking about 50, 60, 70% of your income being tied to those reimbursements, and the mandate comes out before every opportunity or every argument is exhausted through the court system, we could be without funding for a long period of time and face decertification. That's the problem, is timing.
Not this bill. This bill requires that the public entity exhaust all legal challenges
Before we mandate, Mr. Chairman.
Yeah.
But the federal government may require us to mandate immediately.
Hypothetically, yeah. Mhm.
So we don't have that time period is the way that I look at it.
Representative Prego?
Thank you, Mr. Chairman. Mr. Bowley, quick question, and goes along with all these questions that the chairman was asking and Representative Oakley was asking as far as like cover and along the lines of one of my earlier questions about the timeline. So you get a notice from CMS or from the state that you're out of compliance. What's kind of the timeline do you have to respond to that? And B, I mean, as a general rule, I know there's probably different violations that have different ramifications, but that, and then B, what's the legal process for appealing that decision? I mean, when you go through the federal agencies, where do you go? How does that work? Maybe just give me a rundown because I have no idea.
Sure. Mr. Chairman, Representative Craigo. So the survey team comes in, they're usually there 2, 3, 4 days. There's different components, life safety and then patient care areas. So there's 2 different teams that come in. Then they huddle at the end, do an exit interview with administration. They have, I think, 10 days under normal circumstances to compile their findings and citations and have it approved by CMS. And we receive that. We usually have 45 days. This is normal circumstances to file a plan of correction and get back in compliance. But if it's an immediate jeopardy, which Director Johansson talked about, and who knows what they're going to deem this, it's immediate. They may send in a team and shut us down immediately if the patients are at jeopardy. Now, this doesn't really seem to be to that level, but we don't know what they're going to exercise. So then you have 45 days. If there is a immediate jeopardy, normally in that 10-day time period, we'll get a notification that our admissions has been stopped. We'll no longer receive any reimbursement until we're back in compliance. And we have that 45-day period or shorter to get it done. Then the team has to come back out and do a follow-up survey, or they can do it sometimes virtually if we can send photos or whatever it might be to show that we're in compliance or documentation. So it's usually a long process, except when they use immediate jeopardy, which should be only if patients are in immediate jeopardy of definite harm. But again, we see who knows what they're going to do with this. That's again, the problem that we have is it's all speculation at this point.
Mr. Chairman, thank you, Mr. Bowley. I understand that the chairman is basically saying it's a gamble, and I think we could call the federal government's bluff. However, I'm kind of trying to figure out how many chips we're betting in this gamble. For me, that's, I think, the Medicare and Medicaid enrollees and the providers themselves. So I want to get a sense from you on how many members of your association are public entities under this definition, as well as maybe a ballpark figure of how many patients that kind of looks like. Thank you, Mr. Chairman.
Mr. Chairman, Representative, I can't give you total numbers of covered lives. It's significant based off their payer mix, but as I stated, I think we've got about 20 of our hospitals that are at jeopardy and close to 20 nursing homes. The others, the state facilities, which are 5, are also at jeopardy. Our federally qualified health centers, I believe, would also be at jeopardy. Even in majority floor leaders neck of the woods there, I think that the rural healthcare or rural health clinics are also at jeopardy. They don't have 100 employees, but I do believe this is going to stretch because there's federal funding that's attached to rural health clinics.
Vice Chairman Washut.
Thank you, Mr. Chairman. Mr. Bowley, on the other side, the concern that a lot of people have expressed is a nursing home, hospital, whatever, announces a mandate. How many of their employees walk or get fired? And what's that impact look like statewide in terms of our ability to provide service?
Mr. Chairman, Representative Washington, I think it's a great question. I think we can take a look at the one system in our state that's already mandated, and they have had a very small turnover rate. There are a few that are waiting it out to see how it plays out. Got a lot of exemptions that have been offered both through their corporate structure and also here within our state. Close to 10%, I believe, of those that are required to get vaccines have received exemptions. We're already seeing a migration though, just because people are so burned out. And so it's going to be really difficult to gauge whether it's the mandate or whether people are just fed up. But I do believe that this mandate is going to exacerbate the problem. And like I said, I don't see any of our facilities really looking to enact it. We've got some facilities in our state have done a great job on their own. We've got some that are 70, 80% without mandates. They've done incentive programs and other things. Our nursing homes, some are good, some are bad. 45% all the way up to 80% of their employees and 95% of the residents. I think we've made it a long way, and I hope we continue to see that. And from my side of things, I also believe that the threat of this mandate has increased some uptake in the vaccine rates in our state. And I think that might be one of the ploys that the federal government is using right now, is to see how much juice they can get out of the squeeze before they actually enact something.
Representative Larson.
Mr. Chairman, thank you. Is there any discussion in the rules at the federal level of testing twice a week or anything? Has there been anything like that?
Mr. Chairman, Representative Larson, I've heard scuttlebutt. We don't know anything. They're not sharing anything. We were on a call with CMS through our state agency, and we queried them probably 3 weeks ago, and they just basically said, we refuse to answer. We're not allowed to talk about rules under the federal statute while they're in the rulemaking process. Testing is a good option. I think as you look at facilities around the state that are looking at vaccine policy, that's going to be one of them. The thing to realize, there's tremendous expense that's attached to that, especially if you're testing a large number of your employees, but it might be a reasonable accommodation. The other thing is you have to change your staffing levels, because you have to have people that are able to draw them and get the test done. But I think as we look at what we're doing from organization to organization, that might be one of those things in the vaccine policies that they're going to put in place. Oh my.
Did you have a follow-up?
I did.
I'm sorry, go ahead.
I did. I was waiting, but I missed it. Follow up. On the testing, is it always by blood, by taking your sample of blood, or is there a saliva test that that works? Or can you?
Mr. Chairman, Representative Larson, there's several different ways. The most effective one is sticking the Q-tip all the way to your brainstem. There are some rapid tests where spit tests and others, they're not as effective or as reliable. They're getting better, but the most effective one is the PRC, which, yeah, they take a sample.
I always look to the right. I don't know why.
Thank you, Mr. Chair. Mr. Boley, not to belabor this, but it was something that was said earlier, but there's significant federal requirements and federal laws currently in place that do require a certain level of rural health care and for this maintenance of, of what's currently being provided. Isn't that correct? And can you talk about that a little bit? Because it seems to me they would know, just yanking all this funding would significantly put them against their own requirements. Is that fair, accurate?
Mr. Chairman, Representative Oakley, there have been close to 200 critical access hospitals that have closed in the country in the last several years. The feds didn't do anything to step in and fix it. I don't know what exactly this administration has in mind. There aren't specific requirements. I mean, we've got an area of our state that doesn't have a hospital that I hope soon does, but feds don't step in and say, yeah, you got to have one in there. And vice versa. They don't, if a hospital closes, they don't really get involved in that or do anything to bail them out. And so I think it's just part of what happens. I mean, it's supply and demand. It's, the problem that I would tell you is that the financing component and the solvency of some of our small hospitals, they're on razor thin margins already. And so even the slightest bump here could send them over the edge.
Representative Provenza.
Thank you, Mr. Chairman. I keep hearing about a shield or the possibility that having this would provide cover for not following the federal mandate. But as it stands, it's it's probably not constitutional. If you are given a shield that is likely to end up in, say, litigation, or is going to later be found to not be good enough, would you want to use that shield temporarily, knowing that the consequences are going to come later? Or what decision do you make? I mean, specifically in this case, if you think the courts are going to come down on you, even though the state of Wyoming says it's okay, and you're forced to choose federal or state, I mean, what's your choice?
Mr. Chairman, Representative Provenza, I'm not sure how the state can shield us from this, to be honest. That's the concern. I've heard a lot of legislators talk about the fact that I think they're talking about chapter 10 or section 10 of the Constitution that our state law can trump the federal law. I don't think that's the case. So I'm not sure what shield we can build. I don't know if there's something you could build into this, that if the courts win and this is defeated and mandates, maybe there's something we can do to go back against the federal government. I think one of the thoughts we had is we would love to see a strong resolution from the entire body condemning or talking about the mandate itself and push back against federal government. But I'm not sure what shield there is. The Iron Dome doesn't exist for this one that I'm aware of.
Representative Zwanitzer?
Thanks. A hot seat question, Mr. Boley. So if you think of all of your members, your hospitals and your nursing homes, and think of maybe the smallest, if it's $750 fine is not going to be the make or break, give me a number on when it hurts, on when a provider that gets CMS money is going to say, do I comply with the federal government or the state of Wyoming mandate if this bill passes? What is that threshold number that I can put in this bill that makes people, have to make a decision that's not $750? They're not going to care about the $750. What's an adequate number for a civil penalty that says, hey, state law trumps federal law?
I feel like
Mr.
he's
Chairman,
asking
can
you
I
to
take the
choose your own
fifth on this?
sentence.
Representative Zwanitzer. I'm not sure. I mean, in the thousands probably is going to make them at least think. But again, you're talking. It's probably got to be a lot bigger when you consider what's at risk. It might be $100,000. I don't know. $100,000 would ruin some of our hospitals if they had to come up with that immediately. A couple of our smallest ones.
Majority Floor Leader Summers, in House Bill 1, I'm trying to find it, but I feel like we have a provision in House Bill 1 that says that if there is a federal mandate, and if that mandate is in direct contradiction to anything that we've mandated in House Bill 1, then the employers are free to not follow the contradiction. Could we put the same type of language, because we're talking about two tracks, the CMS track and the OSHA track here. Could we put the same language in this bill regarding the CMS issue, that if we found that a facility would have an issue with its Medicaid, Medicare dollars, that we would exempt them out?
Mr. Chairman, you could. Oops, thank you. Mr. Chairman, you could. I think when I went through the bill, I suggested deleting a place.
Okay.
And it does basically the same effect as putting that other section in. But the way you could do it is an entire section that says that section 2 shall go away upon any federal rule that is puts in place that is in contradiction to your. So there's multiple ways to do it. And, while I'm visiting here, one thing that Director Boley brought up that's contemplated in that other bill as well, but it's not contemplated here that you may consider it, because that bill is more or less about private entities. This bill is about public entities. Is you could put together a pot of money that would help with accommodations. So if any of the federal government did come out with accommodations in their rules for these public entities, then perhaps you would have a pot of money available to help pay for, Representative Larson mentioned testing. So maybe we could use some of that ARPA money for these public entities to be able to comply with the accommodation section or to provide accommodations. So
Representative Summers, you're referencing the $1.5 million maximum stipend out of the governor's office. We allocate, reappropriate a set pool of money to him, $20 million to the chief executive, and he can allocate 1.5 million out of that to an employer out of ARPA funds. You're suggesting we could set up the same pool here for those public entities for things like testing or whatever it may be.
Mr. Chairman, there's two pots of money in that bill. And one is specifically for testing and something else. And I'd have to go back and read the bill, but there's actually two appropriations in that bill. I don't know that you have to be as involved in that. That gets really involved language. I think you can do it much simpler than that, frankly, but that was the way that panned out. And Mr. Chairman, while I have it's funny, we talk about, we don't want to put this in place because it's going to hurt these people. I agree, right? We got to be careful. That's what I said to begin with. But it's funny, the last entity that got a hold of me today to fight about over these mandates was my hospital district.
Mm.
They called me specifically and said, we need to push back on these mandates. I think that's something you heard from Mr. Boley as well. I think the question is, how do we do that where we do the most good, the least hurt to everyone? Thank you, Mr. Chairman.
Mr. Boley, do you have thoughts on either of those two considerations, the pool of money to subsidize some of those expenses, or the mirroring the track in one where we exempt out? And I don't know that it exempts out the entity. What it does is it says you basically take you take the state requirements, you take the federal requirements, and where you may still end up with parts of the state requirement that are enforceable and parts of because they contradict the federal regulation. That's the way I read it. It doesn't just mean everything goes away because there's a federal mandate. It means we find out where they can still comply with state law and a federal law. It all goes away. Okay.
Mr. Chairman, we're interested in Bill 1. I've split the baby. I've got my VP over there right now. We do like the provisions in there that provides money to create those reasonable accommodations that we talked about. We've actually been really successful so far working with the Department of Health and the governor's office with some of the ARPA funding to help with a lot of these different things. And so I think that would be great. But my understanding of Bill 1 is once federal mandate is enacted, that bill
Completely goes away.
Yeah, it's done. Except I think for maybe the funding afterwards.
Mr. Chairman, thank you. Thank you, Eric. Mr. Chairman, just that section. So how you'd construct it in this is section 2 goes away, and then it leaves in the sections that you deal with funding and various other things.
Mm-hmm.
If that's how you wanted to go about it.
Okay. That is exactly what I'm looking for. Other questions for Mr. Boley? All right, thank you.
We're not taking the online comment, right? I don't even know if there's anyone in the room. I didn't even know.
Good afternoon, Mr. Chairman and members of the committee. My name is Tammy Johnson. Oh, I didn't want to interrupt you. I feel like that some days too. My name is Tammy Johnson. I'm Executive Director for Wyoming State AFL-CIO. I may be a little bit of a dissenting voice here. Most of our members are Republican, 90%. Most of them don't like the mandate, but many of them do. And I just want to be a little bit of a voice there in what I've been hearing today here in this committee meeting and in some other conversations on the floor, that there are people out there who are unaffected by the mandate. We did what we should do and we got vaccinated, or we're going to do what we should do and get vaccinated. I hadn't looked at the numbers for a couple of weeks, but yesterday the CDC released that Wyoming's 44% vaccinated now, which is, I thought we were still 34, and I was really happy to see that. So I'm not going to say that the mandate is quote unquote working, but I think that we're moving in a positive direction to eliminate COVID. I had several family members who had COVID early on, and it wasn't fun and it wasn't pleasant and it was scary. And I'm glad that they're okay. And I hope that all your family members are too. On a more technical sense with the bill, OSHA is very much in danger with this bill. If we lose our primacy, if we lose our ability to have our own state level OSHA, a lot of things are going to change. And I know Ms. Legursky behind me is going to speak more to that, how it will impact contractors. Wyoming leads the nation in on-the-job death rate. And that was before we had COVID. That was before, for 5 years running, we had the highest death rate in the US on the job. So I think it's really important that we think about those things. There are many members in my organization who are threatening to leave their jobs if they have to get vaccinated. And some of those are federal employees under the railroad system. They're not subject to state law, they're subject to federal law. And that scares me because they don't understand. They're giving up lifetime pensions, they're giving up seniority in careers, they're giving up dedication to a job and a career that they may have been in for generations in their family, because they think that this is a hill to die on. And it may be the hill they literally die on if they don't get vaccinated. But at the same time, I think we need to show a level of leadership in our state that says, let's not throw everything out over an issue. And I worry that we may be sending that message to people that this is worth giving up your career, your life earnings, your pension, everything. And what happens to employees when they don't have that pension? What happens to them? They're in these nursing homes that you're talking about. They're relying on Medicare and Medicaid for the rest of their lives. And we're ready to throw that out too now. So I'm not here to try to tell you to change your mind about the mandate. I'm not here to try to tell you anything. I'm just trying to paint a picture for you that this is extremely heavy and complicated how it hits the ground for the people who live and work in Wyoming. And I hope that we can come to a level of reasonableness that says, I don't like the feds pushing me around. I don't like that you have to wear hunter orange when you go hunting. Isn't that a mask mandate? I mean, if I want to get shot, I can get shot, right? But we're pretty serious about that in Wyoming. So where do we draw the line? And I think we draw it with people being responsible and being self-aware and understanding that we're all in this germ pool together. I used to teach at a high school, and boy, oh boy, you're stepping in the germ pool every day. And I'm not here to advocate for education, but those teachers are wholly unprotected. They don't have workers' comp. They don't have health insurance coverage if they get sick at school, and they have to go work in a place where they're not protected. So I think we need to think about all those things as we move forward. In this case, this bill, the OSHA standard is going to hurt this state and hurt it mightily. So I think we need to be careful about that. So I'm happy to answer any questions if I can.
Committee, questions?
Thank you.
Appreciate your
Yeah.
comments.
Okay.
There's no pool bigger filled with different types of infections and bacteria and et cetera in the Wyoming legislature. So we know that all.
Well, that's why I'm wearing my mask today.
But
I'm sure wish others would.
But I do want to respond to one thing you said, which is I want to drive home, especially for the public, how important this issue, you reference how important this issue is to employees. The consequences of what we do are significant to employees, employers, et cetera, all across Wyoming. And I think we all agree with that, obviously, because we called ourselves into special session, gave up put our livelihoods aside, put our families aside, put our entire lives on hold, came down here. And you could look at the spectrum of this dais, and there's different opinions on the outcome of all of these bills and the outcome of all of this process. But everyone did the same thing, which is we're going to deliberate over these issues because they are so important. I think that's why we're here, because it is so insanely important to the people of Wyoming that we deliberate over these issues. We find solutions if they exist. For those of us that believe that there are solutions, to the extent there may not be solutions, the fact that we're here to deliberate over the issue, I think, tells the state of Wyoming that it's important, that we should be having this conversation, that we should be discussing the primacy of OSHA. And, Ms. Legursky is going to come up in a minute and talk to us about that as well, I'm sure. And the reality is, I mean, that's a policy question too, right?
Sure.
And one that we probably can't, that judiciary is not even equipped to sort out, right? Maybe that's a better question for a different committee, but it's a policy question on primacy, and it's a guess,
Mhm.
right? Because we don't know what the OSHA regulation is. So we can't say that by enacting HB 1002 that we put primacy at risk. Theoretically, we do, but we don't know what the regulations are, if there will be an actual mandate. We don't even know if there will be a mandate. There isn't one. We're assuming it's gonna go through regulation process, right?
Sure.
So I think that's so important, because I don't want this. I don't like when the conversation is so one-sided that we feel like we're the only ones guessing. We're all guessing in this room. Everyone's guessing, right?
Exactly, Mr. Chairman. And I guess that balance of one-sidedness, I just wanted to bring the people who I run with, like the notion that we get people in our state vaccinated, and that people don't leave their jobs because of a principle, because that has devastating consequences. We already struggle with the workforce in this state, and we're working very hard to build that workforce. Policies that emulate from the legislature play a large role in our ability to build a workforce. And this is one of them. So
I guess that does give me a question then. And we asked Mr. Boley this, and it's hard to put your thumb on it, but do you have your thumb on the idea of how many of your members would find themselves unemployed because of a choice that they maybe either way, right? They chose, okay, if we're not gonna have mandated vaccines, and I'm not going to go to work, or if you're going to mandate vaccines, and I'm not going to go to work. Either way, do you have an idea of how many of your members would find themselves unemployed?
I don't, Mr. Chairman, I apologize. I can't guess at that. I know two industries I've heard from are electrical workers and the railroad. And I'm in pretty steady conversation with the IBEW about this. And each one of our unions has national level policies. We have 56 unions in our membership, so it's hard for me to keep track of their positions at the federal, at the national level and the international level. So I couldn't speak to those. I would be able to get that, but I think the bigger point is that this is difficult for everyone, you guys especially. But I do want you to know, when we had our convention, we had about 60 people there, and I was nervous. We're meeting in hotel room, and AFL-CIO National doesn't even want us to do that, but we did do what we want here. And we asked, how many of you are vaccinated if you'd voluntarily? 85% of the people attending were vaccinated. So I felt hopeful about that our membership is concerned enough that they're going to do what will help stem the tide on the pandemic. So I don't know if that's an indication of our membership. It's just the leaders in our membership.
Right.
So I do worry that people will give up long-term things like their careers over this issue. And if I were queen for a day and we said, okay, everybody, it's okay to go get vaccinated, it's okay to comply with the mandate, and we all went and got vaccinated, then we went on down our lives, this whole thing would go away. And they wouldn't lose their jobs, and they wouldn't lose their pensions. And 20 years from now, we'd be, boy, we're sure glad we did that. But 20 years from now, we may be saying, man, you don't have a retirement account. Your family's in poverty. That was really an unfortunate position that you put yourself in. So.
Vice Chairman Washington.
Thank you, Mr. Chairman. Just a comment in response to something you said is I'm not aware that the state of Wyoming has encouraged anybody to give up their pensions and quit and die on the hill, as you said. But rather, I think that that's an individual decision that your union members are making on their own. And probably the union is in a better position to dissuade them of that option than is the state legislature. That's just my comment.
Mr. Chairman, Representative Washington, thank you for that comment. I agree with you. I hope that those decisions that the union does step in and help them with those decisions. But as you know, many people claim that it's an individual sort of decision. And even though it's a public health issue, it's an individual approach. And I'm just here to share with you some unanticipated consequences that are very painful and difficult for this state to deal with in the long term. So thank you for hearing me. And I'll let Ms. Legursky talk about OSHA because she's more.
You
Oh,
sure?
Sorry.
Because I think Representative Provenza wants to
I'm
talk.
happy to sit
She
here
might
and take
ask
some
you a question.
bullets.
Thank you, Mr. Chairman. Ms. Johnson, do you know how approximately any number of people within your membership would be leaving their pensions or who work under federal guidance, right? Because maybe there's the possibility that the legislature, in trying to support people who don't want to follow those mandates, support those folks by paying for pensions, unemployment. Do you have any guess on that number?
Representative Olson, Chairman Olson, Representative Provenza. I don't, but I do want to remind the committee of one thing. Before Congress right now is the infrastructure bill, which means a lot of money in jobs for Wyoming, a lot of improved infrastructure, roads, electric vehicle charging stations, broadband. There's about 7 categories of improvements that will be coming to this state, and those are going to be federal dollars. And so how are those going to be impacted? We're trying very hard to build that workforce that we're going to need. We're going to have a small scale nuclear reactor that's going to be under the federal government. We're going to have government contractors here building missile silos here in Southeast Wyoming. That's all going to be connected to federal money and federal guidelines. So I think the exponential experience of this is going to be much bigger even than what it is right now. If the way the federal law plays out, that we don't get any federal money if we don't, follow the rules. So I couldn't give you specifics on my organization, but I can tell you the future is bright for Wyoming with jobs that are coming that are going to be federally funded, but we might not get those. And we might not get that money.
Thank you.
You
for your
bet. Thank
comments.
you. You guys
Appreciate
have a
it.
great evening.
Ms. Legursky.
Good afternoon. Thank you, Mr. Chairman and members of the committee. I'm Katie Legursky with the Associated General Contractors of Wyoming. This is a very difficult position that Wyoming contractors are faced with. Right now, we do fall under the federal executive order for federal contracts. We do have a number of contractors currently working on federal contracts. It's our understanding that within a couple of weeks, the federal government's going to come in and do change orders and mandate that all federal contractors follow the vaccine mandate. Not only is it the contractors, but the contractors are also going to be responsible to ensure that all their subcontractors, not just tier 1, tier 2, tier 3, anybody who touches that contract, whether it's a person in the office working on payroll or it's somebody working in HR, every single one of those are going to have to be vaccinated in order to continue working on the federal contract. We've already signed the federal contract, so we would face liquidated damages, strict timelines. So we're already under that. In fact, there's a project that's going out to bid in Natrona County, I believe on Thursday, that just got an addendum added to it from the federal government that says the mandate is in effect. We have a number of Wyoming contractors right now trying to determine if the $6 to $8 million project is worth it. There are some contractors that will go ahead and mandate the vaccine in order to bid on that contract, and there's some contractors who won't. Then we come to the federally assisted contracts. Those are the contracts put out with the Wyoming Department of Transportation, for example. Those are the ones that will fall under the OSHA rules and the OSHA guidelines. As we all know, we haven't seen the final rules. We don't know when they're coming out. There is a rumor mill out there that said it could be as a matter within a couple of days to a couple of weeks. So we really don't know. We do believe it will include the mandatory vaccination or the weekly testing. We know that for sure. We also know that on October 19th of this month, OSHA notified Utah, Arizona, and South Carolina that it was initiating reconsideration proceedings to revoke those state plans, those OSHA-run state plans, because they did not adopt the OSHA healthcare emergency temporary standards that were issued on June 10th, 2021. We know that in several states right now, they stand to lose their state OSHA plan because they're not following the federal guidelines. That could happen in Wyoming, and that's what concerns us. If we were to lose the primacy over our state OSHA. Obviously, we would like to continue working with the state agencies rather than have the federal government come in. So that's where we have our concerns, is on the policy level. What bills that would be passed that would put us in direct conflict with having to implement the OSHA rules at the federal level? What is that going to do with our state funded OSHA? That's where our concerns lie. And I'm happy to answer any questions.
Ms. Lizgorski, what happens if a majority of states lose primacy over OSHA?
Mr. Chairman, if the states lose primacy over OSHA, federal OSHA applies. Federal investigators are the ones that come in and investigate our job sites.
What happens if a majority of states lose primacy?
Mr. Chairman, I'm not exactly sure. It's
Right.
Again, it's up to the federal government. I believe there's 22 federally, 22 state plans through OSHA.
22, does that include the states that you just referenced
Correct.
that would lose their
Correct.
primacy?
Correct.
So a majority of states already operate under
Federal OSHA. Correct.
federal OSHA.
Correct.
So we would operate like the majority of states do?
That would be my understanding, Mr. Chairman.
And what were the states? You said Utah, South Dakota,
It was Utah, South Carolina,
Oh,
and
South
Arizona.
Arizona. Committee? Representative Williams?
Thank you, Mr. Chairman. Ma'am, I'm just curious, to your knowledge, are any of the contracts that you're seeing within the state of Wyoming, are they honoring exemptions? So religious exemptions, natural immunity, et cetera.
Mr. Chairman and Representative, when it comes to the federal contracts, my understanding is there isn't any exemptions.
That could come out in, is it possible that those exemptions could exist in the rulemaking process when they come out?
Mr. Chairman, it is possible when it comes to the OSHA rules and regulations that it is possible that there could be exemptions in those.
Because I think earlier you referenced Executive Order 14042, which is the basis that just simply says, okay, there's a mandate on any entity that has a federal contract or federal employees. And then what we're, just so everyone's clear, what we're waiting on right now is the
Federally
meat
assisted.
of that. That's just the overarching concept. There's going to be a rulemaking process to that.
So, Mr. Chairman, my understanding is that on federal contracts, when a federal government agency is the contracting agency, it's 100% vaccination. That's already under the executive order. Then the OSHA order will go to the federally assisted contracts, such as the YDOT contracts. They're federally assisted because the federal government is not the contracting agency. Those are the rules and regulations that we're currently waiting to find out what there's going to look like going through the rulemaking process. Is there going to be a rulemaking process? Will Wyoming have the 6 months to implement that? Will the federal government or the rules include that it has to be immediately? There are two separate ones. The federal contracting entity already has the mandated on it for the vaccine. We're waiting on the federally assisted contracts that OSHA would have jurisdiction over.
Right. So on the executive order track, we're dealing specifically with federal, that's specific federal that we're obviously not touching at all in our
Correct.
conversation.
Correct.
We are dealing with the entities that may be subject to the OSHA regulation, which we don't know exactly what it says yet.
That is correct, Mr. Chairman.
So I suppose do you have a better guess at what you think that the OSHA regulation might say to be, and I say that, but I say it purposefully because if we're going to say that we're going to jeopardize OSHA primacy, then we would have to know what the regulation says to know that. If we don't know what the regulation says, how can we say that we will jeopardize OSHA primacy? We could, I get that part, but I just want to understand if there's something specific that you know that I guess I don't know that would automatically jeopardize OSHA primacy by passing this bill.
Mr. Chairman, our concerns is that depending upon what it comes out in the rules, if it's implemented immediately, as we have seen in the other states when they didn't implement it, pretty much right off the bat, that OSHA notified those states that they're looking at revoking their state primacy over the OSHA. That's mainly our concerns, is that that could be a possibility here if there is some sort of state law that would prevent the Department of Workforce Services, who is the enforcement agency for Wyoming OSHA, to implement the new rules that are coming down. We don't know what those are going to look like. We're all fairly certain it's going to be mandatory vaccine for those with 100 employees or more. We have concerns. Is that at the height of the construction season? What time period is that? Because contractors in the state of Wyoming, they very well may have 75 employees for 3 months out of the year. For the other 9 months, they may have 200, 300, 400 employees, depending upon the workload. So we're not sure how the rules and regulations are going to look. We're just concerned about if anything happens on the state level that may prevent Wyoming from implementing the federal rules, where the federal government come in to try to revoke all primacy on Wyoming OSHA. That's where our concern lies. Unfortunately, there's no easy answer because we don't know what those rules are going to look like. We don't know what legislation may come down at the state level. We're just wanted to share and express our concerns that because we have seen it in 3 other states where federal OSHA came in and said, you guys did not do what we suggested. So we're going to start the process to revoke your primacy. We would prefer not to see that in the state of Wyoming.
Right. So I guess those states, it sounds like they have a right to cure process. They can essentially comply. I mean, just worst case scenario, obviously. Worst case scenario is we pass HB 1002, chief executive signs it into law. Some employers, public entities decide they're going to follow the state directive here and not enforce the federal mandate. Then we receive a letter from OSHA, and then worst case scenario, we come back in February and we say, okay,
correct.
Now let's have a huge discussion about primacy and whether we want to be like the majority of states that fall under federal OSHA, or we want to continue to be the path that we've been on, right? Which is we have primacy over our own OSHA. And I'm not at all suggesting that we want to be under federal OSHA. I'm just trying to map out if those consequences come to fruition in our worst case scenario, because I think this committee is very receptive to your concerns and your association's concerns. Our worst case scenario, we would have our own right to cure through those agencies potentially. They could then decide themselves, okay, we'll pay the $750 fine to the state of Wyoming instead. Or alternatively, the state of Wyoming, when it comes back in February, when the legislature comes back in session, could say, well, this is a bad idea, right?
Correct. I can't disagree with you on any of that, Chairman.
Okay. All right.
We just wanted to make sure that the committee knew our concerns, and if at all possible, we would really enjoy keeping
Right.
our primacy over state-run OSHA.
Right.
So it's kind of, honestly, what came first, the chicken or the egg? That's exactly in the situation that a lot of contractors are finding themselves right now.
Representative Yin.
Thank you, Mr. Chairman. So I'm trying to get a little clarity on what happened in those other states, Utah. And so they're over June 2021 COVID rules. So is it that their state didn't enforce the federal OSHA rules, or they didn't promulgate rules themselves that are supposed to match up with the federal rules? Do you know, Mr. Chairman? Ms. Legursky?
Mr. Chairman, I do not know the exact details of what has taken place in each of those individual states. But obviously there is enough concern from the federal government that they did not enforce OSHA's healthcare emergency temporary standards by the date that it was suggested that they're coming in to look at revoking their state OSHA. But the particular details of what took place in each of if there was anything at the legislative level, was there not? Unfortunately, I don't have that information, but I'm happy to pull some of that together for you.
Mr. Chairman, if I may follow up. So I really do wish Department of Workforce Services were here so we could question them, because I think that is an important detail, because this bill says that a public entity can't enforce any mandate or standard of the federal government, whether emergency, et cetera, that for a COVID-19 vaccination. So if an OSHA rule came down that said all employers, which is basically what the press release said, all employers that have over 100 employees are required to vaccinate all of their employees. If the reason that the Utah folks were reprimanded was because they didn't promulgate rules on their own, I mean, basically this law would prevent Department of Workforce Services for promulgating a rule to match the federal OSHA rule, right? So then my concern, and maybe, and I'm just wondering what your thoughts on this is, if we pass this bill and the idea that the federal OSHA would slap us down if we didn't promulgate a rule at all, then I think that is a concern where we might lose primacy before February comes around. Do you think that's a possibility, Mr. Chairman, Ms. Legursky?
Mr. Chairman, yes, of course, it's a possibility.
So, Mr. Chairman, I think we should follow up with DW, Department of Workforce Service, if we can at some point.
No, thank you, Mr. Chairman. I just appreciate your time just to hear that, what our concerns over the primacy of OSHA are. So we appreciate you guys coming. We appreciate you guys getting together and talking about some very difficult decisions and some very difficult issues that our citizens are facing here in the state of Wyoming, especially our private businesses. So thank you very much.
Thank you. What did we, or do we have one individual signed up on virtual?
We do, Mr. Chairman. I will go ahead and let him in. Mr. Boner. And he's free to turn on his mic and his video.
Okay.
Hello, Mr. Chairman.
Hello.
I would like to thank you all for allowing me the opportunity to pitch a little proposal on behalf of the Wyoming Press Association. I'm Bob Bonner. I am a past president of the Press Association, and I'm the owner and publisher of the Newsletter Journal in Newcastle, Wyoming. And we looked at the bills for this legislative session, and after looking at them, this one in particular seemed interesting to us because it seemed like a perfect place to implement a proposal that we have. And that is that you use an old tool of democracy, namely newspaper public notices, to buy some additional time, flexibility, and maneuverability for the state of Wyoming and its citizens and businesses. I did email all of you language of a brief proposed amendment. Mr. Chairman, is it all right if I proceed? I'll read it out loud if you would.
Let's pause for 1 second. You
Okay.
said you emailed that to, did it go to the entire committee?
To the committee this afternoon.
We've got it. Go ahead.
Okay. Thank you, Mr. Chairman. The language would be in section 2. And what I would propose and what we propose is a new letter C that would bump down, the existing letter C would bump down to letter D. And it would simply say, upon certification from the governor, the Secretary of State shall order 3 publications of the federal government mandate or standard in each newspaper of general circulation published in any county in which employers will be required to comply with the mandate or standard. The publications must appear on 3 successive weeks, and employers will not be required to comply until 30 days have passed following the 3rd and final publication in that county. We offered this as an effort that newspaper public notice, it's the old, what is old has become new again. Newspaper public notices were identified specifically by the founders as a mean to protect the population, to ensure well-informed citizenry was capable of self-government, and to ensure that government is accountable to those citizens by shining the light of transparency on actions our representative government feels it needs to take on our behalf. The unpopularity of things like mandates was specifically one of the things that the American Revolution took place in response to, and newspaper public notices became a staple of the federal government immediately upon us establishing a federal government. We would suggest that this is another remedy to combat specifically what the special session was called for. I know there's a lot of trepidation on the part of businesses about piling mandates on top of mandates. This would seem to be something that would give the legislature, give the people, give businesses a little extra time if indeed something is certified and is going to come down the pike that affects all of us. And if OSHA or the feds are going to suggest skipping a public comment period, I would suggest that language like this in one of the bills that the legislature passes would perhaps give us an extra legal leg to stand on to oppose the federal government moving forward without a comment period. They really are standard and customary. And I think it would behoove the legislature to consider including this language in any legislation you're looking to pass. We thought this one, it fit particularly well with.
What's an idea of the cost?
Mr. Chairman, that would depend on how much language there is in the mandate. One of the benefits of newspaper public notices is that they encourage brevity and clarity. You don't want to weigh things down with a whole lot of words that the general public won't understand. So in that respect, I think there are really effective pushback against federal overreach. And as I said, there are pushback that was specifically embraced historically and customarily by the federal government themselves. So I think they would be hard pressed to this particular standard if the state of Wyoming put this in legislation as an expectation that we would have before we would enforce compliance with any mandate. And I would expect, I apologize, Mr. Chairman, I'll continue that as far as paying for it goes, I would imagine that this would be more than eligible for ARPA funds. Again, I would think the burden of paying for it could reasonably and should reasonably be placed on the federal government. It's their mandate. You as a state legislature are simply taking a step to ensure that your citizens are appropriately informed and given an appropriate length of time to appeal that mandate. It's not your mandate, it's federal government mandate, so they would be responsible for paying for it.
I suppose the notice kind of depends on how prescriptive the language is here. I suppose the notice could simply require the citation to a website or some other source where the full language of the mandate could be found, as opposed to publishing the full length of the mandate? Or do you envision the full length of the mandate being published in the notice verbatim?
Mr. Chairman, for the purpose of encouraging brevity and clarity, which I think there has been, if you read some of the emails I did send to the members this afternoon, I understand we're all rushed, so you probably haven't had a chance to yet. Probably one of the primary failures and the reason we find ourselves in this position with a special session staring down mandates is because really the whole COVID thing, especially at the federal level, is amounted to a massive failure of communication. I think it's appropriate for the state legislature, again, in pushing back against the federal government, to suggest that first and foremost, they need to communicate with people with more clarity, with more brevity, and with a lot less confusion. And I would suggest you put it to people in writing. Even a year ago, when mandates were coming out in states, I think they would have been a lot more palatable to people had they seen them where they're used to seeing things like directives from government or emergency. I mean, people expect to see things posted. They expect to be able to sit and read and consume them. And we now have a lot of other sources with the internet and things where we do that. But if anything else, COVID in the past year has taught us that sometimes too many sources can create even greater confusion. So no, I would, sorry to shorten things up, I would suggest that no, you require the federal government, if they're going to put a mandate on people, then one of the ways to keep the language brief and clear is to make them pay by the word.
Committee questions? All right. Anything else, Mr. Bonner?
No, sir. I do thank you for the time. Appreciate the committee's time.
Well, perfect. We appreciate you giving us your insight. We appreciate you sending this to us in writing and in advance too. And you're right, our day's been a little chaotic and busy, so we haven't been able to digest all of our emails yet, but it's always nice to have that in writing. So appreciate that.
Thank you, Mr. Chairman.
Is there anyone else here in person wishing to testify on House Bill 1002? Okay, seeing none, did you have more you wanted to, are you just coming up while we work the bill? Because what I was gonna do, Majority Floor Leader Summers, is I was actually, if I have no more public testimony, I'm thinking I'm gonna close public testimony. I'm gonna take a 15-minute break, let my committee members stretch and get some water and coffee, and then we'll come back and work the bill. That sound good? Okay, then we'll go to a 15-minute recess, please.
Yes, there. I hate federal mandates. I love state mandates.
Maybe so. I don't know. I know they were getting us dinner too. It might be on there.
Okay, I'll go check.
Yeah.
Yeah.
They need a couple of a lot of people have jobs that pay. I mean, it's ag season for about 2 or weeks. So all the ag. There's a lot of people that roll stuff. Hard to have a football. Oh my God, yes, I think But so we have about now we could be doing this every morning. Something to break it. But I don't think we're gonna do too much more. I don't think the Senate Council there's we are only more. And then they did only they fix others that I mean, yeah. Oh, no.
Is it? What is it? Pork sandwiches and mac and cheese. Ooh, that sounds good.
I think I'll go after the meeting though.
Yeah. I mean, we won't be the last people here because the attorneys can't leave until like they write their amendment. I'm gonna run to the restroom. Okay. Where's the class?
Do you know where it is?
Is there one on this hall?
Yes.
Down here?
Yes.
Okay.
And then you take the.
Okay.
Ooh, are you enjoying it? First session. Yep. It's interesting. Yeah. You have to take work off. Yes. And I have to take work off. We had Judiciary corporation. Okay. Then follow. Yeah. So 3 weeks in a row where that is hopefully one job.
We put it in unemployment free. Put them all in. Free money for everybody.
Yeah, as far as for accommodation, how it should.
Public comment on House Bill 1002. Let me first ask if we have a motion on the bill.
Move the bill.
Bill's been moved by Vice Chairman Washit and seconded by Representative Lawson. Bring in Majority Floor Leader Summers into our committee discussion. You might have some, based on the discussion we've been having with the public, you might have some different suggestions.
Well, Mr. Chairman, I just think broadly, what are your options? One, you can kill the bill. That's one option. Not my preferred, but you can do that certainly. Two, you can strip out section 2 and it becomes strictly a findings bill and a funding bill. And then 3 is you can keep in section 2, leave it as it is or modify it. And so, you and I talked a little bit about House Bill 1001 and the fact that in a separate section, it had a thing. Well, it's almost the exact same language. So what I'm going to do is read to you what is section 6 in 1001. It says the date a federal law, regulation, rule, or standard takes legal effect that has the effect of requiring Wyoming employers to comply with a federal COVID-19 vaccine mandate and any challenge to the federal law, regulation, rule, or standard in the federal courts system is exhausted. So it uses similar language and so I'll read that again. Let me read how that starts so you understand how it starts. The provisions of section 2 of this act shall be repealed upon the earlier of sunset date or the date.
Majority Floor Leader Summers, hold on 1 second. So my committee is tracking us. We are reading the language of House Bill 1001, Section 6.
Correct.
I don't know what
Mr.
page
Chairman.
number it is, but go ahead.
It's a section, starts on page 14 and goes
Page
on to
14?
page 15.
Okay, go ahead.
And so let me start over. So basically, the provisions of section 2 of this act shall be repealed upon the earlier of a sunset date, which is Romanet 2, and Romanet 1, which is the date a federal law, regulation, rule, or standard takes legal effect that has the effect of requiring Wyoming employers to comply with a federal COVID-19 vaccine mandate and any challenge to the federal law, regulation, rule, or standard in a federal court system is exhausted. So it uses that same thorough language. And so, Mr. Chairman, just to bounce back to further confuse you and bounce back to my bill. One thing that you guys noticed right off the bat is that in my B, no public entity shall enforce any mandate or standard of the federal government. It doesn't say anything about imposing their own mandate prior to a federal mandate. So that's one decision you could make depending on what you want to do. You could put something in prior to a federal regulation being imposed if you wanted to. And then remember the suggestion I had was if you're worried about the challenge through the courts and what effect that'll have on the various things you heard, then really, I think you need to go in on page 6, line 23, starting at and you strike the rest of that line. And on page 7, you strike all of line 1 and you strike line 2 through exhausted. That's if you want to be sure you're not going to be pitting one against the other in law. And then I think the law, and you guys are the Judiciary Committee, whether you want a penalty, if you have no teeth in a law, do you really want to pass law that is going to get violated because people have to violate? That's a question we as the legislature have to ask and answer. So, Mr. Chairman, those are some of the options I see that you have. Thank you.
Committee?
You ready for amendments or is this questions, Mr. Chairman?
Just want to make sure real quick, no members have any questions for Majority Floor Leader Summers based on some of the suggestions. If not, then yes, I will entertain any motions you would like to make.
All right,
Representative Swanson.
Mr. Chairman, I'm going to go for the big one first, and if that doesn't work, I'll have some small ones later. But my first motion, and just conceptually, it takes out all the findings and takes out everything besides the money and the AG power. But for the motion's effect, I would move that we delete pages 1 through 5, and then we would
Or in other words, just delete section 1.
delete section 1.
Okay.
And then on page 6, we would leave in lines 1 through 12 to still define what COVID-19 is and a vaccination, and then delete the rest of the bill up into page 7 with section 3.
You want a global motion.
It's a global motion to really delete everything besides leaving section 3 and 4 with a definition of COVID-19 vaccination. So we would still give the AG and the governor's office $1 million, tell them to go take any and all legal action to resist federal government interference, but save our public entities from being in interesting controversial positions.
Is there a second on the motion? Seconded by Representative Yin. Further discussion on the motion. Representative Yin?
Thank you, Mr. Chairman. So, I think it makes the statement that the legislature said that they wanted to make, which is we want to fight the federal government mandate. We're willing to put our money behind where our words are, without the necessary risking of a whole bunch of people, their jobs and their healthcare, their access to healthcare, right? So we have that risk of people losing the ability to find providers near them to the point where maybe they'll have to go out of state depending on which providers decide that they no longer want to be Medicaid or Medicare compliant. So that's why I'm in favor of it. Keep that statement that legislature seems to want to make without pitting our providers and our workers and our contractors at risk in the middle. Thank you, Mr. Chairman.
Further discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
All those opposed? That motion has failed. Another motion.
Mr. Chairman, I can do this all day. So let me take an agreeable, friendly one.
We can do this all.
On page 4, line 2, I just want to add the words COVID-19.
Sorry, what page?
Page 4, line 2.
Okay.
After the word please insert COVID-19. And so this is in the findings. It talks about the COVID-19 vaccination everywhere else. And I'd just like to add COVID-19 here. As you know, school districts already require a host of vaccinations, et cetera. And I don't want there to be any unintended consequences with this bill. So I'd make that motion to add COVID-19 on line 2.
Seconded by Representative Craigo. Any discussion on the motion? I think that one seems pretty straightforward.
Got to get everybody to agree with me now.
All right. Should have started with that. All those in favor of the motion signify by saying aye.
Aye.
All those opposed, the motion's been adopted. Hopefully that made pretty good sense. Okay. Just checking with LSL.
I got another one, Mr.
As
Chairman.
many as you like.
Tempting. So committee would be at the bottom of page 6, after line 23. And this is what we just alluded to. After the word mandate, put a period and delete, starting with and any challenge to the, and then all of lines 1 through 4 on page 7. And
1
so-
through 4 or 1 through 2?
1 through 4, because I don't believe the governor needs to certify anything that all legal remedies were exhausted. And so this still says when it takes legal effect, it's good to go. But I mean, we've been challenging some court cases for 30 years federally. So this just takes out the interesting standard that everything has to be exhausted from the legal realm. It just says when it takes legal effect. And I would, if I get a second, I can further explain.
Seconded by Representative Provenza.
And then
Can you start by explaining the deletion of lines 2 through 4 of the governor's certification?
And so, yes, Mr. Chairman, I believe in how I read it, the certification part of the governor shall certify the occurrences really is based on how many challenges are left out there. It's not based on when the legal effect takes place, but certainly an attorney can argue with me on that. But I believe the certification is that all legal avenues have been exhausted not that the legal effect date when it takes place. I think that's pretty clear when the federal government says by this date. It just gives a date certain in our law. And I think that's better than having people argue when all remedies were exhausted in a federal court, which might not even be in the 10th Circuit.
Majority Floor Leader Summers.
Mr. Chairman, I just ask, to read the plain language of that. The governor shall certify to the Secretary of State any occurrence subject to this subsection. So then you got to go back, right, and read all the occurrences. And the occurrences would include what entities do or do not enforce the regulations, be my guess. So I just want to make you understand, I guess you need to be sure of what you're doing, Representative Swanson, and if that's your intent, that's fine, but just understand the plain language.
Yeah, I would, I read it as the chief executive is certifying more than just that the action in the court has been exhausted. So I would move to amend this, Representative Swanson, maybe take it piece by piece. I think there's a consensus to delete line 23 after mandate through line 2 to the period. I think there's a consensus to do that. Representative Grego.
I'll wait till you're done. I apologize.
I would, Mr. Chairman, let me amend my motion at this time, if it's okay with the second, just include the first 2 lines then through the word exhausted, period.
Who was the second? Representative Provenza? Fine with that? Discussion on this amendment?
Thank you, Mr. Chairman. I guess a question for the bringer of the amendment. What is the point of that particular subsection if we take that language out? So we're saying you're not going to enforce the mandate until the mandate goes into effect. So we're just saying, what exactly are we saying with that provision then if we don't leave the challenge? I mean, my thought of this bill was we were buying ourselves time. And I actually believe that the provision that you're proposing to strike is the most important provision in the entire bill from my perspective, because it buys us time. Right or wrong, I'm not saying it's a good idea or bad idea. I mean, I think it's a good idea, but that's probably something we should let the body decide, I guess, is where I'm going with that. And because once we take that out, all we're saying is you're not going to enforce a mandate till the mandate goes into effect. Well, I guess I don't know the point of that because the mandate's coming soon. So it would buy us maybe a week or 2 of public entities could not, but we don't even know what the mandate's going to say, whether they're enforcing it, not enforcing it. So I guess I just throwing that out there. What are we accomplishing if we take that out?
Representative Swanson.
And thanks, Mr. Chairman. And so I'm not sure that it's coming soon. I keep hearing that it's going to for 6 weeks now. And maybe it's the question on takes legal effect. And so in my mind, how this would work, how it's going to work if this keeps going the way it's going is federal rules come out, maybe there's no comment period. Some entity or state runs to a federal court somewhere in the country and you get an injunction. And I think that's the most likely that's going to happen, and they stop it from ever taking legal effect for however long that judicial process takes. And so I'm not sure if there needs to be that element of time. Maybe there does. But when I think it, in my mind, and I'm not the attorney, right? It's always great to argue with my colleague who is an attorney, that legal effect doesn't actually take place probably for a very long time in the future because you will have a federal injunction. But again, I don't know that because I don't know when the rules are coming out and I don't know what they say, which is why I have difficulty with all of this because we're fighting against something that is still amorphous at this time.
Vice Chairman Washit.
Thank you, Mr. Chairman. I guess my question on that line is if it goes into effect and is in effect for some period of time, and then there's a stay, has it gone into effect, had legal effect, and does the statute kick in or does it not? And so it had legal effect for some period of time. And I think that ambiguity creates a problem for us.
Mr. Chairman, I don't know the answer to that either. I would tend to agree with Representative Washit. Vice Chair, once it's promulgated, and we may not be able to challenge it until it actually goes into effect, the day it goes into effect, then you run to the courthouse, file your action that particular day, because otherwise if they could withdraw it at any particular point in time, the administration. So until it's actually promulgated and is enforced against the country, we can't challenge it. And so I think it's this weird little nuance in the law, which was why I tend to like the language that the amendment would take out. And maybe we need to flesh this out a little bit more, talk about it a little bit more. But essentially what Representative Zwanitzer is saying is an injunction falls under the challenge to the law. And so that's why I thought the language, I agree with you. That's what's going to ultimately hold up the enforcement of the mandate is an injunction somewhere along the line. And maybe the injunction gets struck down right away. There is no injunction. And, you know, I don't know. I don't know what will happen. We can't foresee the future, but that's why I like to leave the language in. It gives us a little flexibility, because otherwise, once it takes effect, it's done.
And Mr. Chairman, just for that entire sentence, it's not only it takes legal effect, but the legal effect that has the effect of requiring Wyoming employers to actually comply. I think that's one more level of safety, but it bothered me, any challenge to exhaustion. I mean, that leaves a lot of people in other murky waters of one goes down, court case gets decided, somebody else runs to another circuit, puts one right back in and files one the same day. And it's so difficult when we don't have clarity on what the rules are and when they're coming into effect is the problem we're going to keep going back to. So vote your conscience on the amendment, I guess. I just think it makes it cleaner, and I understand the representative next to me thinks it makes it murkier. It's tough to argue. I don't know either.
Okay. Ready to vote your conscience? All right. All those in favor of the amendment signify by saying aye.
Aye.
All those opposed?
No.
That amendment has failed. You wanna-
They can have any one.
You want to, okay, go ahead, Representative Oakley.
Thank you, Mr. Chair. I move to strike lines 6 through 10 on page 7.
Okay, delete subsection C of section 2. Great.
Correct.
Seconded by Representative Zwanitzer. Discussion on the deletion of the penalty. We might have consensus. All those in favor of the amendment signify by saying aye.
Aye.
All those opposed? That amendment has passed. Further amendments? Representative Yin. Oh, I'm sorry, Representative Williams.
Thank you, Mr. Chairman. I move to amend line 23 on page 3, where it states prior recovery from COVID-19, and change that to including natural immunity from COVID-19.
Okay, so you want to delete all of line 23 and replace it with natural immunity from COVID-19? Natural immunity of COVID-19? What did you say? Of? From?
Yes.
Hold on one second, Majority Floor Leader Summers. Do we have a second? Seconded, okay.
Mr. Chairman, I don't want to
Go ahead.
butt in, but this has been debated a little bit internally. I don't know why they did this exactly, but But proving a natural immunity is assuming that you know exactly the level of immunity. I'm a cow guy, right? And so when I give a vaccine, I give a variety, different levels of immunity, and it may not be in a full immunity. And so I think it was just, rather than get into the biological science of what immunity is, I think it was decided in this verbiage to use prior recovery. Then we're not making a science-based decision. That's kind of the argument of why we went the way we did. Obviously, you can do whatever you want, but that's kind of where.
Okay. Further discussion, Representative Oakley?
Thank you, Mr. Chair. Just again, for discussion, we could do both prior recovery or natural immunity from COVID-19.
Would you like to make an amendment to the
If,
amendment?
that's up to, is that a considered friendly amendment?
Mr. Chairman, I would consider that a friendly amendment.
Okay, so, and the second agrees. So it sounds like it would read something like, keep the language as is, just add or natural immunity before, from, and before COVID-19. Representative Provenza.
Thank you, Mr. Chairman. What is natural immunity and is it defined in state statute?
Thank you, Mr. Chair. I don't believe, correct me if I'm wrong, that it is defined, in which case the law says that the ordinary and understood meaning of the words is what is used, since obviously everything's not defined.
Representative Provenza.
So my follow-up to that would be then what is the the consensus on the meaning? So what's the general meaning? If you were going to define natural immunity, what is it?
Representative Larson, did you have a question? Go ahead.
I like the amendment, the way it sits, because you may not know that you had it. It might have been so mild or something, and you could be tested for this, I think.
I mean.
You were
yes,
so
that
mild.
happened. I was mild, so I got antibody.
And that provided Vice Chairman Washit just enough time to go to dictionary.com.
Actually, I went to the CDC,
Ah.
Mr. Chairman.
Okay,
And CDC says natural immunity is acquired from exposure to the disease organism through infection with the actual disease. And then it goes into defining what vaccine-induced immunity is. So I think there is a common understanding of what the term means.
okay. Question. Further discussion, ready to vote on this amendment? All those in favor of this amendment signify by saying aye.
Aye.
All those opposed?
No.
That amendment has been adopted. Further amendments? Representative Williams.
Thank you, Mr. Chairman. On page 4, line 4, I move to add the word coercion in front of intrusion. So coercion, comma, intrusion or dictate.
Second.
It's been moved and seconded by Representative Zwanitzer.
Want to get an Oxford comment?
Is the Oxford comma friendly? Is it friendly?
Oh, sure it is.
Okay. Well, not everyone, I am an Oxford comma guy. Not everybody is. Do we not use it in our? Yeah. We could add a section to this bill requiring the Oxford comma in every section statute of Wyoming law.
We could put knowingly as well.
Oh, we're still finding this.
Did we lose the feed?
When you see Mike go that way.
When I see Mike go that way, usually it means that I've lost the Zoom. Okay, oh, he's getting green books. Okay. Representative Yin is also our resident technologist. So this server used to go down a lot on us during session, and Representative Yin knew how to go into that room and get us rebooted. So that's what I was nervous about. Okay. Further discussion on this amendment. All those in favor of this amendment signify by saying aye.
Aye.
All those opposed.
No.
All right, guys. All those in favor, raise your hand. Okay, all those opposed. That amendment is passed. Further amendments to this bill?
Taking discussion yet?
If there are no more amendments, any more amendments to this bill?
On the amendment, but I'll have discussion.
Okay.
Ready.
Discussion on this bill. Representative Zwanitzer.
Thank you, Mr. Chairman. And I know this is an important bill to the majority floor leader and a lot of people. And I actually voted for the amendment that took out C with the penalties. I don't believe I can vote for the bill now in general, because what we've actually done is allowed any competent and smart attorney, now that it's the law, right, can sue for any amount of damages as a civil penalty for violation of the law for any public entity. So our community colleges, our hospitals. And I just think you're opening the door to a massive amount of litigation that that's already the most passionate, controversial issue, we'll be dealing with in the state for the next couple of years. And so it just really worries me that we're putting all of our public institutions at risk of lawsuits that, probably won't go all the way through, but they'll settle, and it's still going to be a burden and cost to the taxpayer. And I know this is one of those bills that there's no way to win. But before we have further guidance from the feds, I really just hate to take this step and put that liability for litigation on all of our public institutions. And I'm not ready to do that unless someone can tell me that litigation isn't going to happen.
Okay, further discussion on this bill? All right, Vice Chairman Washit.
Thank you, Mr. Chairman. I'm left with a conclusion today that I think is obvious, but I'm going to state it. And that is the state of Wyoming, like probably every other state, is addicted to federal dollars. And we're never going to be the independent sovereign that lots of us talk about wanting to be, as long as we are receiving millions and millions and millions and millions of dollars from the federal government. Much like a rebellious teenager who, lashes out at the parents, there's only so far you can go because your parents got the checkbook. And I think that's kind of where we're at in this situation. We've heard from our hospitals, we've heard from contractors, we've heard from nursing homes, education, and all sorts of other folks who've at least suggested that, there's only so much we can do in this circumstance with the federal government threatening these mandates. And lots of it comes back down to the fact that we are so dependent upon the federal dollar. So stating the obvious, my 2 cents worth, I'll be an aye vote.
Representative Yin.
Thank you, Mr. Chairman. So, I think based on the audience that I see in this room, this bill wasn't the bill that the public was actually asking for. It wasn't necessarily to fight federal mandates, even though this is the specific bill that does that. And so I'm a little unsure why we should pass this if all the public comment that we've been given is wholly negative, and the possible effects that it'll have on each of our communities and their healthcare providers. I think that ultimately, even if it was a bill that we wanted to do and that we should be doing, it's still premature. So I think we could know better on how to target federal mandates if we knew what the federal mandates were. Unfortunately, We don't have that ability. We will have it in February. I'm pretty sure that we'll have that ability. And the question is, what is the reason to do it now rather than to do it in February? I think the gamble that though is that you have the possibility of harming a lot of people by doing it now. While in February, you will actually have something that we can actually respond to and construct actual language around. Right now, we're guessing. We're guessing. And with the idea and thought that we can fix it in February if we do screw up. And I think that's a terrible way to create law. So I will be voting no. Thank you, Mr. Chairman.
Representative Oakley.
Thank you, Mr. Chair. Briefly, I guess possibly in response or just in discussion, but from what we just heard, saying that this isn't what the public, wants from us, but I think overwhelmingly what we have heard from Wyoming people and our constituents, the most reiterated concern is about federal overreach. I am concerned, and I don't want to put Wyoming people and our medical facilities in a bad position. But we've come here to have discussion, to have debate, to see what we can do, to see if there is a way we can push back against the federal government and what they're proposing. I don't know if this is perfect. I have concerns about, obviously saying, don't do the federal mandate, and then we wait for the federal mandate to come out. Of course, that's concerning, but I guess at this point, I feel like that's what we've come here to do, is to have that discussion. This is one vehicle, and I think it should go to the floor for further vetting and debate. So I'll be an aye vote.
Representative Provenza.
Thank you, Mr. Chairman. I think the original intent of this bill was to help shield people from federal overreach. I think that the unfortunate reality is that due to the consequences of trying to help those people to stop the federal overreach, we're creating state overreach, and which is resulting in an unconstitutional overreach. It's confusing. It's not going to be helpful. It's also not going to be a shield, at least not an effective one. And we keep talking about risks of, well, let's call the bluff. Call the bluff of the federal government, see if they're going to shut down this hospital or that hospital. And I don't know if anybody else here has played Texas Hold'em, but it seems to me that what we're holding is a pair of twos. And we've got no business calling a bluff when the other party might be holding aces. So I'm a no on this.
Well, before we vote, I just want to make a few comments. I just really appreciate the public weighing in on this bill. Definitely appreciate the agencies, appreciate the association weighing in on this bill. And to that is a significant point, because just have to, respond to some of the comments that are made. I wholly disagree that this wasn't the bill that the public wanted to hear. The director of the Department of Health was here. We had the hospital association here, where the vice was sent down the room to the other bill, and bills are being held simultaneously. I mean, I wholly reject that idea. I think that, the room could be filled or not, but, what I heard from the hospital association, what I heard was that some member entities don't want to be told what to do by the federal government. In fact, I heard that most entities don't want that. I heard when in taking out the penalty, I heard from the Department of Health that they don't need a penalty in a bill to follow state directive and state law, because they want to do that. And I think that's true. I don't think that the penalty is the only way that you can guide agencies. I understand deeply the dynamic that we have with the federal government and what we are trying to accomplish with this. I think that I'm going to vote in favor of this because I'm going to send it to the floor because we're here. We're here to continue to deliberate over these issues. In a perfect world, yes, I would have preferred this bill over an interim. I would have preferred to have more public testimony, I think, to the point of the good minority caucus leader. Yes, I would have preferred that too. And I would have preferred to have the association come back with answers to our questions and the Department of Health come back and continue to deliberate it over an interim. I always feel more confident when I come back into a session and I have a committee bill because it's been vetted through months and months of time. But we're not operating in a perfect world right now. We're operating in completely unprecedented times. And in my perfect world, the federal government wouldn't have mandated such a thing on the people of the United States. So I think we're here to try to do what we can and find solutions and continue to have the discussion. So I think the discussion needs to continue on the floor of the House. With that, we'll go ahead and call the vote on the roll call on the bill, HB 1002.
Mr. Chairman, this is a roll call vote for HB 1002, Federal COVID Vaccine Mandates, Prohibition and Remedies. Representative Crago. Representative Larson.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
No.
Representative Williams.
Aye.
Representative Washut.
Aye.
Representative Yen.
No.
Representative Zwanitzer. And Chairman Olson.
Aye.
Chairman Olson, that's 6 ayes, 3 noes.
All right, committee. With that, unless there's any other thoughts, we will be adjourned. All right, we're so adjourned.